All right, everyone. Thank you very much for coming today to the Civil Justice System for the 21st Century Conference. Got a great lineup of speakers covering a whole range of issues relevant to the civil justice systems. The origins of this conference is essentially a British Academy Fellowship that I've been given, in which I'm exploring what can reasonably be expected of civil justice systems in the 21st century, where they're working, where they're not working, and why, how they can be improved, how they interrelate with dispute resolution mechanisms outside of court adjudication, and also ways in which civil justice systems, and we'll get in a later panel, can be used not just to resolve disputes, but to actually advance them, to spot them, to hold corporations and governments accountable for historic and major failures. So it's a very tight program. We've tried to leave as much space as we can in for questions and answers. I've instructed my students to ask as difficult questions as possible of the speakers. You're free to choose to answer them as you see fit. For the speakers, we do have time minute cards down here from our wonderful student helpers. So they will give you time cards at the 8-minute and 10-minute mark. And we're going to go straight away to our first session, which is focused on empirical insights into civil justice systems. It's somewhat ironic that we even have this session on the program, because most of the people in the room are disciples one way or another of Professor Adrian Zuckerman. And anyone who knows Adrian Zuckerman knows that all problems can be addressed from first principles, and then analyzed through first principles, and then concluded through first principles. And so it's, but that said, a number of his disciples have actually now branching out into looking to areas of empirical legal research and how the civil justice systems are operating in practice to improve the number of megapixels we have about how the system is working in practice. So that's our first session. Our first speaker is Rabia Assay, who's a associate professor at Haifa University. He's a Palestinian Israeli. He does lots of really interesting work, both combining philosophy, doctrinal accounts, and also empirical legal research. And he's going to present to us for some recent work he's doing into social perceptions of lawyers. So over to you, Rabia.
Well, thank you very much, Andy, for inviting me. It's always a pleasure to come back to Oxford, and thank you everyone for coming here to hear my presentation. So I hope that I will not upset too many of you by the end of this presentation when I talk about all the bad things that are being said about lawyers. So I will start with kind of a puzzle, a paradox. How do I... okay, is there a way? I start with a puzzle about lawyers and about legal representation. So on the one hand, we all know that legal representation is very important. It's very important for the rule of law, for access to justice. And lawyers have had a leading role in reforms, in defending human rights and protecting minorities. And if we need any evidence for the importance of lawyers, we can find it in the public struggles for enhanced legal aid. So that said, on the other hand, there is a persistent image, a negative image of lawyers as greedy and as manipulative, and that image actually transcends time and place. And I'll show you, I'll review some of the gems in a moment. The question that I would like to ask in this presentation is, what's wrong with lawyers? I mean, what is it about them that attracts such aggressive criticism? Just to give you just to give you some background, I mean, just to make sure it's the idea is not that lawyers are generally disliked or that the negative perceptions are more dominant than the positive one. It's just that there is sometimes, from time to time, there are negative perceptions, and these persist. They have been there for centuries. And the question is why? Why does that happen? So I brought you some of the some quotations. I'm not going to read all of them for you. And these actually demonstrate this anti-lawyer sentiment. If we look at, for example, at Gulliver Travels, at Jonathan Swift, so he describes lawyer as a society of men bred up in the art of proving by words multiplied for the purpose that white is black and black is white, according as they are paid. But perhaps the most famous line comes from Shakespeare's Henry VI. And he describes a scene you're probably familiar with when two rebellions want to liberate London from the rule of the monarch. And then they start discussing what's their plan for the day after. And then Jack Cade asks Dick the Butcher, so what shall we do? And Dick the Butcher says, well, first thing we do, we're going to kill all the lawyers. Now, the interesting thing is, and I don't know if you are familiar with that, is that this actually happened. 70 years before Shakespeare, there was the Peasants' Revolt led by Wat Tyler. And actually, one of their kind of genocidal demands was the death of all lawyers, and actually of all those who could bring a claim or write a letter. And that led to a massive spree against killing too many lawyers. And then if we move forward to the 17th century, to the Civil War, we have lots of evidence for anti-lawyer sentiments. For example, the Levelers or other social movements who, and look at the gems, really, look at the descriptions that they have been, that they used to use against lawyers. Locusts, vermin, caterpillars, the chief bane of this poor nation, beasts who destroy the wealth of the state, unchristian sinners, deadly enemy of the ministry of the gospel. And that was not just historical examples. We also have some intellectual background. So look at Bentham. Bentham, we are all familiar with his sinister interest charge against lawyers and judges. And when he spoke about the legal profession and the jargon, the legal jargon, he used so many pejorative words such as legal profession is sham science, is a spun of cobwebs, massive rubbish, heaps of filth, etc., etc. And we have also similar examples, similar statements by Karl Marx, who, we thought that lawyers mystify the law and they use it to preserve kind of mystify the defects and conceal the defects of the law, etc. So the question is, why? What happens? What's going on with that? Is this just an historical example or historical examples, or is there any more contemporary evidence for that? And as you can see, I'm not going to review all the data, but there are a lot of empirical, I would say, indications, surveys, and also academic studies that show that significant portions of the public here in this country and in other countries, they just don't trust lawyers. They don't think that lawyers tell the truth. They question their honesty and their ethical standards. So we have data from Australia and even from civil law countries, Netherlands and France. And it's important to address this question. Why is it important? It's important because of all the reasons that make us defend legal representation as a safeguard for procedural justice. It's very important. If people distrust lawyers, they are likely to distrust the entire legal system. Lawyers intermediate the legal system, they intermediate authority, they're intermediaries for the court. So distrust of lawyers will probably lead to distrust of the entire legal system. And we have a lot of empirical data from the procedural justice literature led by Tom Tyler and others, saying that people care a lot about the process. It's not just about outcomes. It's also about being treated with respect, having faith in the decision maker, in the authority, having faith in the neutrality of the authority, and also having an effective voice. So procedural justice matters, and the social image of lawyers actually matters for that purpose. I would like to introduce two sets of hypotheses that, in my opinion, that I suspect that they could explain the anti-lawyer sentiment, and I'm in the process now of examining some of them. And if I'll have enough time, I'll also review some of my temporary findings. So the first hypothesis is the following. I suspect that many people believe that they are entitled for direct access to the law, that they feel that there's something about the law that entitles them with direct access. And here's my explanation. When we go to a doctor or physician, we usually, the situation is structured as follows. We have a problem, we have an illness for which the medical law is not responsible. It didn't create it, but we have a problem and we go to the doctor and we feel comfortable paying them for receiving a service, for solving our problem. With lawyers, it's different. And that's what makes the lawyers stand out. Oh no, just 2 minutes. Well, Professor Zuckerman told me, well, focus on just one point, otherwise you will be lost. But I did listen to the advice. So I'll just finish this point and then. With lawyers, it is different. It's different for the simple reason that the law creates the need for itself. It actually imposes itself on citizens. It's a communicative act. It seeks to regulate behavior. So if you want to speak to me directly, not through intermediaries. And I believe that this leads to many people thinking that lawyers should, the idea of having to pay fees for understanding the legal environment is not very straightforward, as surprising as this could be. And also, the law is not just a communicative act, it's also a political act. It allocates resources, it structures powers. So those who have better access to the law have better access to power and to state power. And that also leads to severe agency problems. The interests of lawyers do not always overlap with those of the clients, which could lead to suspicions, to inherent suspicion in the work of lawyers. Can I go to the my second hypothesis actually is that the anti-lawyer sentiment is not a PR problem. It is actually inherent to the job, especially in the adversarial system, which is unique to common law countries. The job specification of lawyer is to be a partisan, one-sided player. They are not objective professionals. They defend one position for one party, and then they are likely to argue against the same position for another just because they are paid by a different client. So the adversarial, yes, I will, thank you. So within this system, there is a very short leap from the adversarial system to the idea that lawyers actually, they are hired guns, they are mercenaries. And very often we could collapse the distinction between lawyer and client, the moral contagion. So if we believe that everyone is entitled to representation, but when the lawyer represents the bad and the ugly and the morally repugnant, then we are likely to dislike the lawyer because we dislike the client. And that's because the adversarial system emphasizes the one-sidedness. I'll stop here, but I promise you I have a lot to say more, so feel free to ask me. Thank you very much.
Okay, thanks, Rabia. That was fascinating, and I'm sure you'll get the opportunity to expand. So now we're going to go online, and we're going to hand over to Inbar Levy, or we can all see on the screen, and hopefully Inbar can see and hear us. Terrific. So Inbar is going above and beyond the call of duty. Not only is she in a different time zone where it's approaching midnight, she also has probably an eight-week-old baby, possibly a 3-month-old baby, in addition to 2 other kids under the age of 5. So if there are interruptions into this presentation, that's just inevitable. But Inbar Levy is originally from Israel. She's worked in Melbourne. She's now working in Oxford. She specializes in law and psychology, and she does fascinating empirical research into the way in which basically biases and behavioral behavioral consequences of legal rules and the way in which it affects people's behavior and the way it affects the legal system. And we are privileged to get a sneak preview into a major project she's working on, multi-million-dollar project she's working on, into insights into the way in which the open justice principle operates and the extent to which departures from it affect people's behavior across the legal system. So without further ado, over to you, Inbar. Thank you, Inbar. That was terrific. So I've got a couple of quick questions and then we'll open up to the floor. But I think my first question would be to what is to be done, if anything at all, about that historical problem, at which you say is linked to the nature of the legal system, but in particular common law systems. And then I've got also a question for Inbar, which is, do you yourself have an hypothesis about where you think that there is over anonymization, or in certain circumstances that is having a deleterious effect on the administration of justice, but some areas where there isn't enough anonymization, there's overexposure, and that itself has adverse effects. So
yes, thank you, Andy. Well, so what's to be done? I don't know, in the sense that the problems that I think factors that impact the negative effect, the negative perceptions of lawyers are mostly structural, and they're inherent to the situation. I mean, people in the adversarial system, lawyers are one-sided. They are not objective, and people will probably always have expectations for direct intelligibility. Now, obviously, the bar or the law society, the lawyer association, will have to probably do some more public relationships and try to explain or bring more details about about how the legal system works. But luckily for me, as an empiricist at the moment, I focus more on revealing, bringing things up, rather than finding a solution.
That's the question.
It's a good
yeah,
For you ask what can be done, how to establish whether there is a system in which lawyers are viewed in a more positive light.
Yes, so in this empirical project which I'm leading at the moment,
Is there such a system?
well, we are trying to explore whether, if it's true that the adversarial system is a major force in the anti-lawyer sentiment, so possibly it could possibly be that in systems which don't heavily rely on adversarial litigation, which are also more culturally reliant on professional settings, such as in civil law countries, it's possible that the anti-lawyer sentiment there is probably lower or not as intense as it is in the common law countries. And that's one of the things which I am exploring in the project. I still don't have findings, I'm sorry.
It doesn't interest me what you're exploring. What interests me is there such a system?
So I mean, I'm aware of empirical research that suggests that in countries where there's a high level of trust in public authorities, there's also a high level of trust in lawyers. Like, so Scandinavia is an example.
Okay.
So I don't know whether that correlates in other societies as well, but it does seem the case that those societies where there is high level of social cohesion and trust generally in governments, there's also trust in the legal profession as well.
Sometimes it's the other way around. I mean, it's always a question whether what causes the what. I mean, is it the public perception, the public trust in the authority, which makes lawyers look better, or the other way around? I mean, if the bar itself, lawyers behave in such a way.
Oh, so we contribute to the public trust because they trust the lawyers.
Yeah.
Yeah. So
there's also there's a cognitive bias, psychological bias, that negative events have stronger impact than positive effects. So, and because lawyers claim the moral high ground, they say, well, we justify our monopoly because you give us monopoly, we give you high ethical standards. So when they fail, the impact is likely to be disproportionate. And it's going to be apparently, and we are testing that as well.
Imba, do you want to pick up the question?
Yes, I have so many thoughts about Rabia's presentation that it's so fascinating, but I'll talk to him about it afterwards. Yeah, I do think there's too much anonymization. By the way, it's not only anonymization, it's also just publication of decisions. In Germany, less than 1% of decisions are published. So I think that does have an effect on open justice and how the public interacts with the court. Mind you, the interaction with the courts is not always positive, so maybe we want to reduce, interaction altogether. But if we believe that the connection between citizens and the court is important, then yeah, there's definitely too much anonymization. England could be an example of too little. So only in 2015 in England, anonymization became the default in cases involving minors. Now that's not to say that the cases were not anonymized before then, but you just, you had to apply for it. One area that comes to mind, I think, is an interesting one in which decisions are not anonymized is decisions involving tort victims. And we do know from studies that were conducted not in England, but overseas, that insurance companies tend to settle more and settlements fare or claimants fare better when the decisions are anonymized because the claimants just don't want their names and information, to be public, and insurance companies know that. So I think that's definitely something to think about. Yeah.
Right, thank you. Questions? Anyone has any questions for either Rabia or Imba? Okay, thank you. So what we'll do now is we will move to our second session. So thank you. Rachel, do you want to come on down? So I'm going to go with. So while we've got Imba online, I'm actually going to invite Professor Zakharov to begin the presentation, and then we're going to hand it back into the room, back to Rachel Mulheron. So Sam Zakharov is, just put it simply, my favorite US professor. He's a distinguished professor in both constitutional law and procedure, which is almost an unheard of combination on this side of the pond. But it sort of underlines, I think, that the integral way in which procedure is linked to decisions about allocation of power and resources and decision-making responsibility and decision-making systems. Sam has done amazing work over many, many years, highlighting just how these different decision-making procedural choices affect systems and the allocation of power and rights and responsibilities. So, and in this particular session, we are going to focus on a topic that's of fundamental importance to the civil justice systems, which is litigation financing, particularly in a world in which there is next to no public funding of civil justice. And therefore, if there is to be funding, it's usually private. You've already heard from Rabia how grumpy people are having to pay out of their own pockets. So the modern trend is to find commercial sources to fund it for a share of the profits. So without further ado, I'm going to hand over to Sam, who's going to give his perspective on how these issues are currently being dealt with in the United States.
Thank you, Andrew. Can you all hear me well? Yes? Okay. So we inherited from the English the aversion to champerty, maintenance, barratry, and the result was that the operation and financing of litigation in the United States occurred mostly in the shadow world. In very few recent years, we've seen an explosion of litigation finance in the United States and a slow rejection of the British legacy involving champerty and maintenance. And so we have a commercialization of it that is not easily integrated into a culture of silence about the exact subsidies that are public and private subsidies to the litigation system. So let me tell you something about the market in the United States, and I want to divide three parts. And I will say that they present problems of increasing complexity. So the first one is the easiest, and that's the ability to monetize a claim that one has in the legal system. So if I'm the victim of tortious conduct, I'm injured, I either have a jury verdict or I am expecting a favorable jury verdict, I can borrow against that. And increasingly, if I have a verdict, there will be many offers made to me to, in effect, buy the verdict, that is, to advance me money at a high interest rate as against the expected proceeds. There's nothing particularly problematic about this conceptually. We've long thought that a legal claim, a shows in action, is a property entitlement of the holder of the claim. It used to be the custom in Britain that you could not assign legal claims, but already by the time of Blackstone, that position was being derided as something belonging to antiquity. So it's not problematic that people should be able to alienate expected returns in the legal system. The problem is that we are dealing with one-time users of these services on the one hand and repeat players on the other. It's very much like what we call payday lending here. And so you have the usual problems of potential exploitation of the terms. And so this is a market that needs regulation because of the asymmetry in the sophistication and usage by the various parties. The second domain is the funding of law firms, and this occurs heavily on the plaintiff side of the bar, which is accustomed to advancing costs on behalf of their clients, and we have contingency fees that fuel much of our tort system in the United States. But it's increasingly being used by firms on the defense side to simply lay off risk or smooth the period of the collection of fees, especially if they're in disputed domains or there's an insolvency or something of that sort. Now, this is a market that's more conceptually complicated than the first, because what the demand is to create a form of equity in the receivables of a law firm, whether it's a plaintiff's firm with contingencies or it's a defense firm with uncertainty among the client's ability to pay. Typically, this has been done only through borrowing, and we have not allowed equity positions to be given because we have not allowed anybody but lawyers to profit from legal representation. That's a big part of our Code of Professional Responsibility. That is breaking down in a couple of ways. First, 4 jurisdictions have already lessened completely or in part the prohibition on non-lawyers owning pieces of law firms, and that's Arizona, New Mexico, Utah, and Puerto Rico. And we are not yet at the Australian level of selling shares of firms on the capital markets, but there's something pushing in that direction, at least in those 4 jurisdictions. Now, basics of finance is that firms have to decide whether to raise the funds they need to operate through debt or equity. And what we've done up till now is to say that it can only be done by debt for law firms. And the idea is that this maintains the independence of the bar. It's very hard to credit this because when you owe a lot of money to a bank, they in fact own you. And whether they technically own your firm or whether they technically own interests in cases, they can make demands upon you that will force you to conform your behavior to the cash flow needed. So these lines are breaking down, and the capital markets have entered into the United States litigation. And one of the ways they do it is by assuming a bank-like responsibility for cases or law firms. And the line that we've maintained up till now, which is debt but not an equity stake, seems to be breaking down. And that's an area that's going to have to be addressed by the various bar associations. The third area is the most problematic, and that is the domain of mass torts. And in mass torts, you have firms that have to invest greatly in the epidemiology or whatever the evidentiary basis of the claim is. And then you have other firms that basically gather cases and refer them to the most active firms in the domain. That's how it has happened. And we have centralized these claims through processes that are generally called multi-district litigation. That is consolidation of cases for similar treatment at the pretrial stages, but not consolidation of the cause of action the way you do in a class action. One of the efforts in mass torts has been to reduce the entry cost, the overall transaction costs of the litigation. And so we've allowed litigants to what's called directly file into the MDL court. That is, they file a standardized complaint. They don't have to pay a filing fee. We've tried to reduce the transaction costs of the mass harm resolution process. The complication is that that allows other actors to enter. And the United States Supreme Court has ruled on several occasions that lawyer advertising is protected expressive activity under our First Amendment, which means that if you come to the United States and you cannot sleep, you will be confronted on television by ads by law firms looking for victims or potential victims in mass torts. The difficulty is that most often these are firms that are firms in name only. They have a couple of lawyers associated with them, but they are basically vehicles for the recruitment of cases. Historically, what would happen is that the lawyers who advertised would then refer them to the lawyers who would actually litigate them in the mass tort setting. Increasingly, though, we have hedge funds coming in and putting up what are in effect straw law firms, advertising, and then holding these cases, oftentimes not filed even, so that they're not under the purview of any court. So you have a flood of unknown claims that have never been vetted recruited by putative law firms that have no capacity to invest in the development of these cases and no incentive to do so, because what they're hoping for is that the active lawyers will bring about a collective resolution of all claims, and they can just park their claims into the system and then get compensated at whatever level there might be. Since nobody has ever worked up these claims, nobody knows whether they're legitimate or anything else. And defendants at the end of a long process of litigation of a costly mass tort are inclined to seek global peace and just pay these folks off. This is a shadow world because these cases are heavily unfiled. And they are cases that are a drag upon our system, which means that the real litigants have to subsidize the potential risks that some of these claims may be real. And that means that there's a transactional drag on the system where money is not moving to victims, but money is instead being chewed up inside the litigation process. I got the note. Thank you. And so just to conclude, This third category is the market logic of the first two really coming to fruition. And it has real potential for fraud. It has real potential for harm to the integrity of the legal system. Courts have been reluctant to address the financing of cases because they just don't want to immerse themselves there. But now what you're finding is that courts are insisting on all litigants before them revealing the extent to which there's litigation finance that is underwriting the claims and hopefully not directing the claims. The problem for us is that there's a shadow world of claims that exist only in the hearts of financiers and have not been under the control of the formal legal system. I'll stop there.
Thank you, Sam. That was extremely insightful. I'm going to ask some questions about that shadow docket. Our next speaker is Professor Rachel Mulheron, who has worked at QMEL for 2 decades now and in the collective redress space for almost all those years. She is quite simply the encyclopedia when it comes to collective redress law and practice and litigation funding, to the point now where in any law reform debate, when people are having discussion about, well, what should we do in this space, the usual first recommendation is do what Rachel told you to do 10 years ago, and you ignored it, right? And so many of the debates in this area is just trying to catch up with Rachel recommendations from some time ago. Rachel has more recommendations for us now, and for the CJC and for the government, and we're going to hear some of them now. Thank you, Rachel. That's right, if that makes sense. Okay. It's working. It's working.
Great. Well, good afternoon, everybody, and an extraordinarily generous introduction from Andrew, the likes of which I've never heard before. Thank you very much. I will try to step up to the mark, but thank you to Andrew for the kind invitation to present to you this afternoon. And the topic is about financing and facilitating redress for mass harms. So I'm going to concentrate on 2 particular topics. The first is that I'm going to argue that more funding options are desirable for mass harm litigation in this country. And secondly, I'm going to say that the biggest issue of the 21st century for funding in this country is PACCAR. And I'm going to revisit that decision and, yes, suggest that what might be done. So let me start off with the first section, and that is that more funding options should be considered. Now, I think it's incontrovertible that the architect of civil procedure in the 21st century, Sir Rupert Jackson, was very much of the view that there should be as many funding streams as possible for access to justice. And indeed, in his final report, he says it's desirable that as many funding methods as possible should be available to litigants. That was when he was recommending that damages-based agreements or percentage contingency fees be added to the menu of funding. And then, ironically enough, the Court of Appeal, when considering the validity of such a DBA in Zabiro and Lexlaw, said again, there should be as many funding methods as possible available to litigants because that would promote access to justice. Now, the central thesis of this first part of the presentation is that that has not been borne out in mass litigation instituted in this country to date. What's the reality? There's just shy of 70 collective proceedings that have been filed in the Competition Appeal Tribunal in relation to the opt-in, opt-out regime for competition law grievances. All but one of those have been funded by professional third-party funders. There have been significant opt-out actions brought under the representative rule, now in CPR 19.8, the old 19.6, and they've been third-party funded, Lloyd and Google probably being the best known of them. And there's been several high-profile GLOs, Dieselgate and the RBS rights issue amongst them. Now, third-party funding is essential to those regimes, and indeed the CAT regime couldn't survive without it. But it is my contention that we need to look seriously at other funding options. Now, damages-based agreements, those lawyers' fees based upon a percentage contingency basis, they are banned from use for opt-out collective proceedings under 47C8. I think that we need to reconsider that. There is empirical evidence around the world that lawyers can do this cheaper than funders can. Now, of course, adverse costs must always be covered. That is a primary point of justice, that no defendant should be put to costs of defending a claim successfully and not be able to recover their costs. So some law firms might be able to cover that themselves. They might be able to pay the premium for an AT insurer to do it. The premiums are expensive, sometimes up to $6 million, but some law firms have been in a position to do that. With respect to a CLAF type fund, now this of course requires government seed money, and so that the money is put into a pot, and then that money is used for a couple of things, probably own side disbursements, certainly adverse costs, and then a 5-10% creamed off the top of class actions, judgments or settlements, and then ploughed back in. It's a self-perpetuating type fund. We don't have such a thing in England. It has been considered. It was indeed considered by the Department of Business, Industry and Skills back when the CAT regime was introduced, but wasn't implemented. And I've mentioned on this slide various bodies which have looked at the idea. Now, I am absolutely of the view, I completely accept that in the current climate, no government is going to cede a CLAF fund at the moment to the tune of whatever it might be, $1 million or upwards. But I think that if we're serious about considering other funding options, we need to think about it. With respect to before the event insurance, most people in this room hold BTE insurance. It's in your contents insurance, your mobile phone contract, or whatever it might be. Most people don't know it. But in most people's contracts, have upwards of $25,000 available for legal expenses insurance. Now, when I did the report for the Civil Justice Council on BTE insurance, the insurers around that table said that although collective proceedings were typically barred in BTE insurance policies, that's not to say that couldn't be revisited by BTE insurers grouping together. And I wonder whether for opt-in collective proceedings, we need to think about that a bit more. So with respect to the funding landscape, the thesis is I don't think that, well, actually, I think that there's a lack of competition on funding in the competition law sphere in the CAT, no pun intended. And I think we need to look at that. The second part of my presentation is PACCAR. It is extraordinary, isn't it? Is there any area of civil justice that has moved as quickly and as hugely as third-party funding in this jurisdiction? It wasn't even approved until 1994 in Giles and Thompson. And so that was the green light, but the brakes got put on with respect to PACCAR in 2023. All of it involves vehicles. So it's ironic, but it's these leading cases all involve vehicles of one sort or another. But what does PACCAR mean for those who are not as familiar in the room with the decision, and of course for our international friends as well? It all turns on the definition of a damages-based agreement under Section 58AA of the Courts and Legal Services Act. Now, just, the logic is here. An agreement, a DBA is an agreement between a person providing blah, 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 all claims management services and the recipients of those services, where the amount of the success fee is to be determined by reference to the amount of financial benefit recovered, by reference to the amount recovered, which is a percentage contingency fee. Now, in PACCAR, the Supreme Court held by a majority of 4-1 that third-party funders offer claims management services and hence are caught by Section 58AA. That means that their litigation funding agreements are damages-based agreements. Now, what does that mean? What has it meant? It's had two immediate impacts. First of all LFAs, which are now DBAs since 2023, must comply with the damages-based agreement regulations. Now, the widely held view and endorsed by the dissenter in PACCAR, Lady Rose, is that LFAs cannot be drafted in accordance with the DBA regulations. That means that percentage contingency payments by funders are simply unable to be enforceable. They cannot comply with the DBA regs. But it's even worse with respect to opt-out collective proceedings, because remember I said that any use of a DBA is banned with respect to opt-out collective proceedings under the CAT regime. So any LFA that is based upon a percentage of recovery by a funder is a DBA and is banned from being used to fund collective proceedings. So what did funders do? Overnight, there was chaos. and funders typically renegotiated their LFAs with their funded clients so as to take a multiple of costs approach. That is, I've taken an example from Alex Neil and Sony. The funder's fee should be the greater of a multiple of costs invested or committed, and only to the extent enforceable or permitted by law a percentage of the proceeds. Now, that italicized bit is put in there in the hope that PACA may be reversed by legislation. The very fact it was put in there was challenged by a defendant as to whether that brought the entirety of that funder's fee down as being invalid, as being a DBA. But the Court of Appeal, I thought, showed great sense there in saying that no, that is a perfectly permissible clause. But you see immediately the funders now having to charge a multiple of costs. They cannot charge a percentage any longer because that's a DBA, and the LFA cannot comply with the DBA regulations. So there's been two consequences. First of all, it is not rocket science that as soon as the funded client and the funder are no longer on a common percentage of recovery, but where the funder is rewarded for the multiple of costs incurred, there is a misalignment or a potential misalignment between the funded client and the funder. And this point has been picked up in Apple and Goodman. Indeed, Lord Justice Green said that there's a perverse incentive on the funder for there to be higher costs incurred because their payment depends upon the multiple of those costs. But there's also a consequence for historical or closed LFAs, where the success fee has already been paid by a funded client to the funder as a percentage of recovery LFA under a closed LFA, when immediately you have the concern of restitutionary claims. That is a payment made under a mistake of law. Now, my information is that those claims have already started being brought. They haven't entered the public domain yet, but they exist. And for that reason, long limitation periods applied, 6 years from the date of mistake. This could be very messy for a while. So in relation to the tactics to reverse PACA, there were always going to be two. There was going to be, first of all, the option of accepting the ratio of the PACA Supreme Court decision and accepting that third-party funders do offer claims management services, but define the LFA so as to be brought out of the bigger set of DBAs, define an LFA specifically to take it out of the DBA bigger set. The other option was to reverse the very ratio of PACA by saying that third-party funders do not offer claims management services. Now, in relation to the steps taken so far, what a road it has been. With respect to the previous government, the government finally put forward a single issue bill called the LFA Enforceability Bill, entered into the Lords, and their device was the first of those, to define LFAs as an agreement that is taken out of the set of DBAs. They said that it should be retrospective and prospective in effect, which was very important to cover those historical LFAs. That bill washed up and issued soon after. The Prime Minister at the time called the general election unexpectedly, and despite cross-party support, it was never returned to Parliament. The Civil Justice Council has since reviewed in its final report that, as I've said, and as I've highlighted here, that the decision in PACA should be reversed, should be retrospective and prospective, and to promote certainty, its recommendation concerning the reversal of PACA ought to be properly implemented as soon as possible. So the CJC would have taken a different tack. They would have taken that second option. They would have declared that third-party funding services are not claims management services. It's the different approach. Doesn't matter. Either would have worked. Then, in the 17th of December 25, Minister Sackman, the Minister of State for Justice, said we will legislate to clarify that LFAs are not DBAs with prospective effect, prospective, not retrospective. And we will introduce legislation when parliamentary time allows. So what happened on Wednesday? Not a word. Not a word. Nothing mentioned with respect to either the reversal of PACA or a wider civil justice bill. Now, the practical ramifications are huge. I've spoken to the Ministry of Justice this week. Of course, I accept that not everything in the King's Speech gets into legislation, and by corollary, things that get into legislation are not in the King's Speech. Of course, one accepts that. But there's also, it is said, the possibility of adding on a PACA reversal to another bill. Look, we've been there. We have had scoping after scoping issues in trying to get this attached to another bill. This is difficult political territory. But the funding market and those who use funding services are really being impacted by PACA. It's the biggest problem with funding in the 21st century. I won't have time to conclude the third part, but it's just to say that retrospectivity and portfolio funding are incredibly important to third-party funding. But to wrap up, more varieties of options for funding are required, and the PACA decision must be reversed legislatively sooner rather than later. Thank you very much.
Okay, thank you for that. It's two terrific presentations dealing with some of the problems that sometimes caused by the courts, sometimes caused by the market. And some of the first questions I want to have was addressed to Sam, and that was about this the leveraging effect and the influence of funders, both in Model 1 and Scenario 1 and Scenario 2 you were talking about. When I was a junior lawyer on the claimant side, I was always troubled ethically about the fact that I was representing people who had no real knowledge of the legal system. And that whenever I was giving advice to them and I asked them what their instructions were, their answer was always, what do you think is best? And that leads to a strange kind of God role that I've always felt uncomfortable about ethically on the claimant side. And now, in a different universe, the litigation funded universe, whenever we're having meetings or strategy meetings, quite often there will be a funder representative, almost certainly from the United States, challenging our strategy, urging us to bring motions, new motions, new procedures, new options. And that's a strange world in which we're now in. But I at least take some comfort that someone is challenging the decisions and the legal strategy we're making, as opposed to on the defendant side, there'll be mountains of in-house counsel challenging everything. So I just wanted to get your feedback on the extent to which funder influence can be a negative development and can be a positive development on the claim path. And then thirdly, what's the solution to this shadow docket if, given you've got the First Amendment framework, is there a solution to that problem? And then I'm going to come back to Rachel first. So over to you, Sam.
The first question is really, is there a role for litigation funding in tempering the inevitable agency costs associated with legal representation? My first article in this domain was, yes, we should welcome litigation funders to play that role, particularly in cases like class actions where the lawyers have no effective client. When you have a big consumer class action, for example, everyone's individual stake is so small that they have no incentive to monitor. And so the lawyers have too much godlike power, as you would phrase it, Andrew. In that circumstance, putting somebody in the mix who also has institutional skin in the game, as we say it here, is a potential source of monitoring that can temper the unilateral conduct of the lawyers. Now the difficulty is there, at least we have the formalization of the relationship in ways that can be made transparent to courts, because class actions are heavily regulated by the organizing court. The more difficult area is your last question, Andrew, which is, what do you do about the shadow docket domain, which exists outside the supervision of any court? And the question is, how do you create the same kind of repeat play institutional barrier to opportunism there that we might have with litigation funders playing a positive role in the class action domain? And we haven't figured that out. The impulse is to try to regulate the lawyers. The impulse is to try to use the tax code to regulate profits made in this way. These are extremely awkward mechanisms because, by and large, our control of the legal system is partially the monopoly on who gets in to be a lawyer, and secondarily, the ongoing court supervision of all matters that are brought into the formal justice system. Once we lose the second part of this, and then these settlements become just matters of individual contracts in the shadows, it's hard for either wing of this to operate effectively. And so I will just say, I don't have the answer, Andrew, but that is the challenge.
Right. Thank you, Sam. I'm going to ask Rachel, give you the floor again. obviously, PACA needs to be reversed. I think everyone's on the same page. Lord Briggs can stay silent, but everyone else in the room. But what I also want to just, would you like to give us your headline thoughts about the CJC recommendations for litigation funding? The bits that are officially endorsed by Rachel Mulholland and those that you think that are problematic. Would you, yeah?
It's really well done. I think it was an enormous amount of work in a short time. I think on very sensible recommendations. I suppose the headline is that third-party funding should be regulated, and I think that's absolutely necessary. There's too much money involved. There's two strands to regulation: capital added proceeding or the prudential regulation is one side, and the other side is the conduct type regulation. And I think that CJC fully anticipated that both of those should be regulated. And my understanding is that that would be part of a wider civil justice bill, of course, the likes of which was not mentioned in the key speech. I think that's extremely important. The second point that I thought was really important from the CJC report is this issue of portfolio funding, which Professor Ishraf also mentioned that in the United States. This is a quickly developing area where funders give a portfolio assistance to a law firm across a range of cases. Now, I think that the Civil Justice Council was very right in saying that the SRA and the FCA may need to get involved in regulating this space. It's incredibly, it's new, it's not, it's an emerging area, but it's also one that is quite, in my experience, at least when doing this funding report, empirical and doctrinal study in 2024, I referred to this portfolio funding, but I found it rather opaque to find out information about it, except that some funders were making this facility available to a law firm with respect to its various claims. So I think that is a very important recommendation of the CJC that ought to be implemented. With respect to generally funding, of course, the CJC talked about many other aspects. I think crowdfunding, for example, we don't talk about it as much, but it's got real potential to be, it should be actually regulated to a great extent like it is. For example, those who give crowdfunding amounts, are they aware of the Arkham cap? Are they aware that they may be liable for adverse costs to the extent of their contribution? Has anyone ever shared that with them? Does that even apply? We don't know. We haven't got a case to that effect. It's really, a grey area. And of course, litigation loans, developing an importance of litigation loans in the CJC report refers to it as well. This is a very quickly developing landscape. So I think the CJC did a really good job of that report.
Thanks, Steve. Questions? Love some questions. Okay. First, one of our students, Dario.
I have two questions following from Sam's response to your questions. First, with respect to the litigation funding.
Can you just speak up so that Sam can definitely hear you?
First, with respect to litigation funding and costs, in terms of who monitors the lawyers, is there not a worry that the lawyers do have a fiduciary responsibility, but the person who is now monitoring them is someone who has a different sort of interest than the claimants, and is sort of dipping into the same pool that otherwise would go to these claimants. So they bring their own sort of set of interest. The second question, with respect to the shadow docket, is there not a potential solution in there being a regulatory requirement upon lawyers to file claims within a reasonable time once that they've been instructed, instead of just sitting on those claims?
Sam, did you hear that?
Yes. So let me start with the second one. The second one, we have a chaotic system of state by state regulation. So if you wanted to require that cases be filed within a certain period of being signed up, that would require all jurisdictions to agree upon that. Otherwise, you would have arbitrage from one jurisdiction to where the cases are technically signed up from one jurisdiction to another. But more specifically on that, you have to worry about second order effects. If we require all cases to be filed within a period of the lawyer getting them, it means that a lot of cases which are now left to be dormant or can simply be resolved privately after a period of time would be forced to either lose the claim or rush into court. And you have to worry about the second order effects if in any regulation about how disruptive is it going to be to the basic framework. And I'm skeptical that we want to force people to rush into the court system. The first question I couldn't hear very well, but it seems to be whether there are areas of regulation available for ordinary people trying to use litigation finance. Did I get that right, Andrew? I couldn't quite hear the.
Yeah, I mean, in substance, it was. Is there a problem that the lawyers are got fiduciary obligations, but
Yeah.
the funders are not similarly constrained, and whether that creates some issues?
Yeah, so the question that courts want to know about is there somebody with authority in the court or over the court proceedings that doesn't abide by our rules of conduct, our rules of ethics? The term fiduciary duty for us is a little bit of a loaded term because it implies some kind of liability regime and a formal legal obligation. We tend to be leery of imposing fiduciary obligations where you can't contract into and out of them. I don't know that fiduciary is going to be the right way to handle it, but could there be problems because the funders operate in a different world? Absolutely. That's the core problem, that we want to make sure that the client retains settlement authority, which is a fundamental of our principles of ethics. We want to maintain that the legal system not be compromised for quick returns. Sure, we allow parties to do that. Of course, lawyers have influence in the way that Andrew said at the beginning, that every client ultimately says, well, tell me what you think, because they came to you because they're not experts in the legal system. It's quite simple. And we want to temper the advice given by certain rules of professional behavior. We're not sure we can do that with third-party funders.
I think it was up here. Yes, you.
Hi. Hello.
Yeah.
Hi, Sam. First of all, thanks for the talk. It's really insightful. I'm going to follow up on the second question that he asked in relation to duty. So, I mean, given that firms exist not just with a duty to clients, but they also have a commercial imperative themselves, hasn't the horse already bolted in the sense that firms can already make money from providing legal services? And given you mentioned sort of that there's both an ability to finance through debt and equity, isn't the answer that actually some sort of equity-based framework for litigation funders to come in actually strikes the more appropriate balance between the duties that a firm has to their clients and their own commercial imperative? Because shall we say, an external party is not tied so much to a particular claim or a contingency, but can actually sort of derive some financial benefit in a manner more consistent with how firms already engage with their clients.
Yeah, I don't reject the premise of your question. So lawyers have to make money. We tend to have two kinds of lawyers in this country. One is lawyers who do make money, and the second is lawyers who were once lawyers but no longer are. So obviously these are commercial enterprises and they have to be able to get returns on that. When they had to raise funds previously, they could not do it by capitalizing the firm's activities. That meant they had to borrow, and because they could not pledge legal returns as an asset, they had to go to markets where their own holdings would be at risk, or where there would be higher rates of interest, or they would have to go to other lawyers to invest in their cases. And that's a highly constricted market. It raises the cost of doing business. It limits the access to capital. And at least we tell ourselves it in turn limits access to justice. The problem is that you cure one agency problem, which is the lawyers versus the clients, by lowering the cost of getting capital, but you may be creating other agency problems, which is that now the funders have their own demands. And because we ignored this problem for so long until it really burst on the scene in the mass tort world, and secondly, in the arbitration world. And note, both of those are domains with limited court supervision. So now we're confronting it, and it's outside the way that we have structured our basic core regulatory function, which is that the litigants are appearing before a judge. And once you take that out of the picture, we have to, it's a challenge to us.
Thank you.
So Rachel's going to come in on this one.
I just want to reiterate that I think that judicial supervision is crucial to how our regime is operating here. Yes, you have your funders and your lawyers and their interests, but I think it can't be underestimated just what the CAT regime particularly is imposing with respect to judicial supervision. For example, they will scrutinise the litigation funding agreement up front, and they will ask for terms to be, or demand that terms be rectified. They have cross-examined a representative claimant on the basis that she may not have known enough about the case. They've insisted that funders abide by the code of conduct that we have in this country, even if they're not a member of the Association of Litigation Funders. That has demanded that they abide by, particularly not exerting influence over settlements. I think that judicial supervision has been absolutely crucial to the regime that we have in place here.
I fully agree with Rachel that everything we've done successfully has been by forcing it in front of the judge. The problem we're having right now is that we've lowered the transaction costs and not raised the scrutiny on the recruitment of mass tort claimants. And so as a result, that domain of court supervision is very weak right now, and in some cases non-existent. That's the problem. But I fully agree with Rachel's impulse that that running this through the courts to the extent we can is the best regulatory framework.
Right. Thank you. Yeah, I wholly endorse those sentiments. Judicial supervision is absolutely key. Query whether some of the things that are coming out of the CAT about how that supervision is exercised, including the treatment of Christine Reefer, is the best way of actually dealing with those agency costs. But that's going to be for another debate another time. But I thank you. Those were two terrific presentations, extremely illuminating. So please thank the guests, and we'll move on to that. Can we get our lawyer panel down next, please? Yes, absolutely. You want to use it? Yeah, just remember it. It's Jed. Yeah, okay, it's clear. Okay, let's get going again. I didn't actually plan it that we would start with the bad reputation of lawyers, followed by the intractable problems of dealing with agency costs, and then bring all the lawyers up to then put them in the spotlight. What I had hoped to do is also just go beyond procedure as dispute resolution and explore ways in which the civil court, civil adjudication can be ways of advancing disputes, advancing rights, spotlighting issues that hadn't been addressed in other fora in other ways. And we have four very distinguished panelists who have worked in private law claims, in public law claims, doing this kind of work. And one of the things that I wanted them to address when they came here was not just the good things, the good works, the good results that come out of these sort of test cases, lead cases, public interest cases, but also some of the challenges involved, right? The ethical problems confronting lawyers when there's a gap between the cause and the clients, or conflicts of interest between client groups, and also just the costs involved of providing redress as well. I'm not going to read out each of our speakers' bios because they're quite extensive and they've done lots of great work, but I'm just going to briefly say on our first speaker, we've got Russell Hopkins from Temple, as a barrister at Temple Garden Chambers. We have Richard Meeran, who's a partner at Lee Day. We have Alice Hardy, who's a partner of Bindmans. And then we have, at the end, we have Stephanie Needleman, who's a legal director at Justice. So I'm going to hand over to, do you have an order? We do not have an order. Okay, so I'm going to, we'll just go from nearest to me to further. So we'll start with Russell and we'll keep going. All right, thank you very much.
Thank you, Andrew, and it's terrific to be here with you all today. The case of Mariana against BHP is one of a small number of business and human rights claims that has proceeded all the way through to a trial and a reasoned judgment on liability. When in November last year, Mrs. Justice O'Farrell delivered a judgment of 100,000 words, finding BHP liable for the 2015 collapse of the Fundão tailings dam in Brazil. And then just last week, the Court of Appeal delivered its judgment, shorter, but still 147 paragraphs, refusing BHP permission to appeal on all grounds. And so the case will now move from the liability stage through to a stage 2 trial focused on quantum of damages that's listed for next year. Now, the claim was issued in England in 2018, and it's fair to say its progress was and has been less than smooth. BHP at first challenged the jurisdiction of the English court and succeeded in having the claim struck out as no less than abuse of the court's process, by reference to parallel proceedings brought by some claimants in Brazil and certain other redress mechanisms that were said to be available to the claimants in Brazil and therefore closer to home. Now, the High Court accepted BHP's application that the scale of this disaster, in essence, made it impractical for the English court to adjudicate on the claims, such that that impracticability meant that it was an abuse of the court's process for the claimants to have even tried. The claimants sought to appeal that decision in early 2021, but they were at first refused permission to appeal on the papers by a single Lord Justice. And that led to an unusual, some might even have said bold, application under CPR 52.30 to reopen what I don't know the exact statistic, but I would venture to guess 99% of cases is a final decision in the end of the road. However, the claimant succeeded in that application, in that 5230 application, in mid-2021, and their substantive appeal was allowed the following year, following 5 days of oral argument, and then the Supreme Court later refused BHP's permission to appeal on jurisdiction and abusive process. So English jurisdiction was secured, and the principles of abusive process thankfully clarified. We then fast forward, there was a liability trial that took place from October 2024 and it lasted until March 2025 in the TCC, who, as I say, Mrs. Justice O'Farrell, as I say, delivered her judgment in November last year. Now, that high-level summary barely scratches the surface of the twists and turns of this litigation. For some cases like this, bringing them in this jurisdiction raise issues about sovereignty, of comity, about the role of litigation funding that we've heard, the role of lawyers, and among other vexed questions. But rather than delve too deeply into those hot topics, my aim is more modest I'm just going to highlight for you 2 or possibly 3, depending on the time, areas which, from my perspective, of someone who's been in the trenches in one of these cases for nearly 7 years, are deserving of the attention of the brains in this room. Now, first, I just want to touch briefly on the procedure for group claims generally. Secondly, I want to just highlight the court's power and indeed duty to actively case manage cases, in particular group litigation cases. And thirdly, if time, I'll touch on disclosure. On the procedure generally, the Mariana claim was not brought on the basis of a group litigation order. None was ever applied for. Now, and that's even so, at the latest count, there's some 600,000 claimants involved. Now, as you all know, CPR 19.22 and the practice direction to Part 19 provides a procedure for GLOs where claims give rise to common or related issues. And then, in contrast, as we've heard, CPR 19.8 has the long-standing procedure whereby a person can bring a representative action where the representative has the same interest as the class. And then, of course, there's the separate procedure for collective proceedings in the CAT. Now, it seems to me that it's fair to say that CPR 19.8 and the CAT procedures have received a lot of attention in recent years from our highest courts and from academia. But what has perhaps received less attention is the GLO procedure in the CPR, how it's working, how it's not, what claims are really suitable for GLOs or other case management powers, and indeed the management of opt-in litigation generally. Now, I was at a Bar Council conference on collective redress last week, listening to Professor Mulherin talk among others, and one of the panelists there suggested that the GLO procedure is in need of a glow-up, as the phrase goes. And I would tend to agree, because the provisions in the CPR on group litigation are incredibly short and actually written at very high level, now in a very high level way. Now, the advantage of that, of course, is that that gives a lot of flexibility to the court, discretion to the judges about how best to tailor procedures to the particular circumstances of the case. But with that flexibility, with that discretion, comes uncertainty. And with that uncertainty comes satellite disputes that can eat up enormous amounts of time, money, and energy. And that process may be more welcome to one side of the dispute rather than another. And I do question whether more could be done to balance the scales here. So it does seem to me that GLOs and opt-in litigation generally are ripe for review to give greater clarity and save costs. Now, just to perhaps make this a little bit more concrete in the last couple of minutes I've got, I'll give you a specific example. So in the Mariana case, the case was pleaded on the basis of a master particulars of claim upon which all claimants relied, and then individual particulars for, as I say, the hundreds of thousands of claimants that had opted into the claim. Now, that sort of model is fairly standard, but the costs of that process, as you might imagine, are eye-watering. It was also hugely time-consuming, even with the technology that was used to turn questionnaires into individual particulars. And even though this did not proceed on the basis of a GLO, it started to look like a GLO in all but name, including the use later in the litigation of a master schedule of claimants in place of a group register. Now, the point I would make is that this process creates an enormous amount of front-loaded work in group litigation. If one does apply for a GLO, one can then have satellite disputes about the GLO order, about what should be in a questionnaire and what should not be in a questionnaire in order to facilitate the selection of lead claimants later on. And that process really does put in place formidable early hurdles to bring these sorts of cases, even where the underlying claim is plainly meritorious and the entire purpose of the GLO procedure or procedures like it is to get the economies of scale when individually each claim on its own might not be economically viable. Now, these hurdles could be overcome in the Mariana case because of the sheer scale of the disaster. But what about other cases? Now, this is one of those areas where it's easy to ask the question, it's harder to come up with an answer. And if there was a straightforward answer, someone would have come up with it years ago. But I do wonder whether there is scope for some sort of more hybrid procedure between the GLO opt-in and the representative action opt-out, so that parties can save their time, expense, particularly in the early phases of litigation, to push back or delay the detailed questionnaires that one does have to prepare, and prepare a highly individualized particulars of claim later on, until preliminary points and issues that might arise in the case can be resolved and dealt with. Because in practice, why that's important is in a case like Mariana, you had these questionnaires, you had these individual particulars prepared back in 2018. So long ago, the process will now needs to be updated. And so I do just raise whether there's some hybrid structure in between the two extremes that may facilitate the progress of these sorts of claims. And I'll stop there for now.
Andrew, thanks for inviting me. Good afternoon, everyone. And I've enjoyed this afternoon's presentations, especially on litigation funding, which unfortunately is not an option. Most of my cases, which are not very attractive to litigation funders. There are exceptions, which I will talk about, one of which I'll talk about today. But sadly, in my area of work, which involves multinational litigation, as people will be aware, there are many examples, recent examples, of environmental and human rights abuses that have been perpetrated, especially around operations in the global south. And key features of these cases, or reasons why they have occurred, are issues around double standards, poor local regulations, lack of access to justice for victims, and because of the corporate veil that exists between a parent company and a subsidiary company, a difficulty in being able to hold a parent company to account in its home base. And as a result of these difficulties, there has been quite a lot of strategic litigation against multinational parent companies, and with the objective of developing the law to facilitate legal accountability of parent companies in the home base, and to ensure that victims can obtain justice in the home base. So what I'll do just briefly is to highlight some of these features by reference to a current case in which we're involved. The Kabwe lead mine was operated by a Zambian company. It's a lead mine in Zambia, and a company that was within the Anglo-American group. Anglo-American, a big multinational mining company. And that was for a period of 50 years until 1974. After then, it was operated by a Zambian state-owned company. In 2020, we were contacted by Ian Lawrence, who was a medical doctor, and what he told us was that he had arrived at the mine as a young doctor in 1969 and saw that children were dying from what he believed was lead poisoning. And so he immediately set about testing the blood lead levels in 500 children and found widespread lead poisoning, and that's by reference to the international standards at the time. He was so concerned that he delivered his report to the mine medical officer on a Saturday morning at her home, because he felt it was so serious that it couldn't wait for another working day. And he couldn't understand why this kind of testing hadn't been carried out by the mine before then, because the situation seemed so obvious to him. Now, his his findings led to further investigations in 1970 by Professor Ronald Lane, who was an internationally renowned public health expert from Manchester University. He went to Zambia, carried out investigations, and he recommended that townships around the mine should be relocated and topsoil in the area replaced. Now, memoranda from the time show that the mine chose to reject those recommendations as being too costly and likely to cause panic. So they were not followed. Current medical knowledge says that there is no safe level of lead. But the situation in Kabwe, 5 decades later, remains largely unchanged. The situation is dire. There is huge environmental contamination around the mine. Blood lead levels of children at the mine are, on average, in the village close to the mine, 10 times higher than the international standard. It's been described, Kabwe has been described often as the world's most toxic town. Now, it's inconceivable, isn't it, that this level of harm, this state of affairs would have been allowed here or anywhere in the West. Why did it happen? Well, I've given examples of key reasons: poor regulation, no access to justice, but also that, frankly, black lives didn't matter. That's the truth of the matter. Now, a class action was filed in South Africa in 2020 against the former parent company of the Anglo-American group, Anglo-American South Africa Limited. And the class comprises 2 subclasses. It's children under the age of 18 who suffered lead poisoning, and women who suffered lead poisoning during pregnancy or may do so during future pregnancy. So those are the 2 subclasses. The class are represented by a South African firm with whom my firm is collaborating on the case. The case also, unusually for my work, benefits from litigation funding, and that's due to the scale of the case. Statisticians estimate that the class will comprise approximately 140,000 people. Now, the current state of play is that we're awaiting a decision from the South African Court of Appeal as to whether or not the class should be certified. If the certification is allowed, then the victims will be able to obtain access to justice in South Africa, and that has been made possible through strategic public interest litigation, both in South Africa and in England. So before the class action was started, and those developments have also made the case financially attractive to a litigation funder. Now, in South Africa, the key changes are one's legal cases, judgments that allowed opt-out class actions. So there were cases which confirmed that even in cases that didn't raise constitutional law points, that class actions, opt-out class actions, were permitted. And then there was another case which laid down the criteria for certification of opt-out class actions in South Africa. So that was absolutely crucial. In England, as I'm sure most of you will know, there has been an incremental development over the past 25 years of common law principles which relate to the imposition of a legal duty of care in against multinational parent companies, and that culminated most significantly in the 2019 Supreme Court decision in Lungoe and Vedanta, and the lead judgment was by Lord Briggs, who's giving the keynote address today. And essentially, the decision was that a a duty could be imposed depending on the extent to which a parent company had controlled or managed or intervened in relevant aspects of the business of the subsidiary, or had publicly held itself out as doing so. Now, an interesting feature of the Cadway class action in South Africa, if it's allowed to happen, is that although Zambian law applies, because Zambia was a former UK colony, the position under Zambian law is that English common law applies unless there is a Zambian statute saying the contrary. So if there is a trial in South Africa of the Cadway case, it will entail a South African court effectively applying English law to a claim against a South African defendant in a case involving a class of people in Zambia whose injuries occurred around a lead mine in Zambia. I think that's quite an interesting feature. When we were first asked to assist the Cadway communities, I was contacted in 2003. And at that stage, legal action was not feasible. It was not viable. These legal developments that I've referred to hadn't happened. And so strategic litigation has enabled this to happen. Thanks.
Okay. Good afternoon. I've been very interested by the talks today. Thank you for inviting me, Andrew. I too work on cases that don't tend to attract litigation funders. Most of my cases are legally aided, which I would say puts me into a third category of lawyers, which are lawyers who are working but aren't making very much money. I am going to canter through my paper. I enjoyed writing it too much, so there's more than I can fit into 10 minutes comfortably. So forgive me. And I won't even tell you what I'm going to talk about. I shall just talk about it. The first case is Al-Haq against the Secretary of State for Business and Trade, which is a case I worked on until the end of last year. It was a challenge on behalf of the claimant, Palestinian human rights organization, to the government's sale of export licenses to sell weapons to Israel. There was, for the first 12 months of the case, there was a series of decisions that the government made to continue selling weapons on the basis of evolving risk assessments, and each time we would have to amend our grounds. So for the first 12 months, it was tedious and time consuming. But then finally, after the first decision that was made after the Labour government came into power in September, was that they would reverse their decision, and in fact they would stop selling the majority of weapons that were going to Israel on the basis of an updated risk assessment that in fact Israel was not committed to complying with international humanitarian law, which is the laws of war. And because of that, their own policy on exporting weapons, the strategic export licensing criteria, would be breached if they continued granting these licenses, and in particular the requirement that weapons should not be sold if there's a clear risk that they might be used to commit or facilitate serious breaches of international humanitarian law. But this decision was subject to an exemption in relation to components for F-35 fighter jets, which it said had to be exempted from their decision because selling these components involved taking part in an international supply chain. It would be very difficult to separate components going to Israel from other components, and they said that there would therefore be a risk to international peace and security. and they would therefore depart from the policy for that carve-out aspect of the decision. We then amended our grounds again and had a rolled-up hearing in May of last year. I won't go through the grounds, but you'll feel free to ask me about them. A frustration in the case was, well, the main frustration was that we lost. And in fact, we, in a way, pulled defeat out of the jaws of victory, because that decision in September 24 was largely what Al-Haq was asking for, which was to cease exporting weapons to Israel. And because we then focused on the F-35 carve out, we were then focusing on really the most difficult part of that decision, and we weren't successful in that challenge. But there were also frustrations within the judgment itself, in particular the way that the case was characterized. And there are two examples here. One is that the court said in its judgment that it was being asked to rule that the UK must withdraw from its multilateral defence collaboration, which we very much felt was a mischaracterization. What Al-Haq was seeking was a quashing order, so that the Secretary of State would have to remake its decision and properly calibrate the risk involved in continuing to sell components, and also to self-direct itself accurately as to international law and whether that decision complied with it. We weren't requiring any dictated outcome. And the other characterization that was frustrating to us was the court's conclusion that it was being asked to rule on the legality of Israel's actions. And for that reason, the court found that the case was non-justiciable. Al-Haq had asked the court to assess whether the Secretary of State had misdirected himself, that the decision complied with international law. It hadn't asked the court to assess the legality of Israel's actions, only to apply international law on the basis of what the Secretary of State had already found, which was that Israel was not committed to complying with international law. So on the basis of that assessment, is it within the bounds of international law to continue granting export licenses? So that brings me to the first pitfall. I've got a series of these throughout the talk, which is the reason the court characterized the case in that way was because in our pleadings, our skeleton, and in oral submissions, on behalf of Al-Haq, we had explained the context in which the claim had been brought. And these were points that weren't relevant to the legal arguments, but they touched on the death toll in Gaza and the international condemnation of Israel's conduct. And the court asked at the beginning of the trial, how is this relevant to the case? Our counsel explained, not really. It's important to my client that these things are said. And of course, Al-Haq were aware that there was a danger that the court would become hostile as a result. And it did, in a sense. It concluded that that was relevant to the case when in fact it wasn't, and therefore the case was non-justiciable. There was another frustration, which I'll try to summarize briefly, but it related to red lines. We had argued that it was irrational, that the government had taken an irrational approach to its assessment of the risks of continuing to export these components, because it had looked at the risk of stopping the exports, which was this threat to international peace and security. It hadn't looked at the risk on the other side of the balance, which would essentially be the risk to the Gazan population. And that was on its own case. And as a result of it saying that that was its own case, at a permission hearing before Chamberlain, who I believe will be speaking shortly, we were refused permission to proceed with some of our earlier grounds that had related to earlier decisions on the basis that they were academic. We had argued that they weren't academic because those grounds related to the methodology that the government had used, but reliant on the government's assurance that in fact it hadn't used any methodology. It had simply decided that there was no risk that could outweigh the risk to peace and security. We were refused permission to rely on those grounds. In the trial, unfortunately, the government did a bit of a volte-face, said in fact it had used very thorough methodology, and the court then repeated that assertion without us being able to gainsay it because we couldn't rely on those earlier grounds. So pitfall 2, we cried foul play. The court wasn't very sympathetic, and also that if there is a factual dispute in a judicial review, they will quite often be resolved in the government's favour, particularly in a case like this, which was perceived to be political. The second kind of case study, I will canter through quickly because there's so many cases that could be discussed, which is about the assault on protest rights, which has been going on for at least 5 years. It's an alarming development in the law. There's obviously been a lot of new protest offences introduced, greater penalties and police powers. 2 examples that I've given there: the Policing Act and the Public Order Act 23. There's also been the prescription of Palestine Action, which has led to up to possibly more than 3,000 arrests of people who are awaiting trial for terrorist offences for breaching a prescription order, which has in fact been found to be unlawful. So good luck to those courts dealing with those prosecutions. But what I'm going to talk about is the growing reliance on injunctions against person unknown. Very briefly, there are a number of issues with them, which I've summarised here. One of the many is the large numbers of people that become named on them who haven't actually been involved in a relevant protest. And I've cited a case there at Transport for London where the judge was not at all concerned that people have been named on injunctions who haven't participated. And the double jeopardy nature of being named on a protest injunction: you are arrested, you're detained, you might be imprisoned, you come out thinking it's all over, but then you start to receive reams of paper in the post because you're named on an injunction. And in fact, you're being pursued for costs of a large corporation. There are means by which corporations and other well-resourced bodies get round criminal law and the protections that are built into it. There's a helpful quote here from Lord Hoffman. I think we've moved on a long way from that. Pitfall number 3, hostility to protests, such that there's now not many protest activities that don't involve a very significant risk of arrest or loss of liberty. Third case study is the World Uyghur Congress case, which related to a challenge to the National Crime Agency's refusal to investigate money laundering in the context of cotton imports from the Xinjiang region, which the World Uyghur Congress argued were likely to be criminal property because of the high likelihood that they were the product of forced labour. It was a very focused challenge, and it was successful before the Court of Appeal, and it focused on 2 discrete questions: whether the grounds that the NCA refused to investigate on were adequate. What the NCA said was that the WUC had to identify the criminal property before it would decide to investigate, which thankfully the Court of Appeal agreed was nonsensical. Also, the Court of Appeal clarified the law on this Section 329 POCA exemption, that it doesn't cleanse criminal property of its criminal nature. It simply provides a defence to someone who receives that criminal property. It was a clarification on the law, and the impacts are limited. NCA now has to redecide whether to investigate. It may not do so, but it's an important clarification, and it's something for corporate due diligence to be mindful of. And the last that leads to pitfall number 4. Keeping the aims of the litigation realistic may mean that you achieve a clarification of the law rather than concrete repercussions. I don't think I'm going to have time to talk about my last case study, but feel free to ask about it later.
Hi everyone, and thank you very much for having me, particularly because I feel like a bit of an interloper here. I am a lawyer by background, but I now like to think of myself more as a recovering lawyer. I don't work in private practice. I work for the law reform organisation Justice, and our aim is to achieve a UK justice system which is fair for all. We do that largely through policy work rather than litigation. And in fact, we don't bring litigation in our own name, and we don't have clients. But what we do every now and again is third-party interventions. And we've got quite a long history of this. We were one of the first interveners at the European Court of Human Rights. We intervened for the first time in the House of Lords back in 1997, and we're actually the first intervener in the new UK Supreme Court in 2009. Now, third-party interventions, I guess, in the scheme of civil litigation are a relatively new phenomenon. sort of 50 years or so ago, they didn't really exist, but they've become much more common in recent years. And I think there's a couple of reasons for that. I think, firstly, the introduction into domestic law of human rights through the ECHR through the Human Rights Act has meant that the courts are now adjudicating on a broader range of policy issues than they previously did. And that means cases have a potential to have a much broader impact than just on the two parties in front of them. And this means there's opportunity, and the court may find it helpful to have more information than the two parties in the adversarial system may be bringing before it. So for us, the purpose of third-party interventions is not to duplicate what the party's already saying, but to add something genuinely useful to the court. Otherwise, we wouldn't get permission. So that's normally legal context, policy expertise, or evidence of wider impact, or indeed sometimes an international comparative perspective. And as in the cases that we intervene in, these contexts, these additional things matters, because it's not just about the parties before the court. It's also about how public power is exercised, whether institutions are acting lawfully, and how legal rights are understood and protected in practice. And our hope is that a well-judged intervention can help the court see the wider implications of the case. It can draw attention to systemic consequences, explain how a rule operates on the ground, or identify principles that may otherwise receive too little attention in the adversarial process. So we tend to ask ourselves a number of questions before we intervene in a case. First, does the case connect with our organisation's strategy, expertise, and longer-term work? Second, can it add something the parties are unlikely to provide? And third, is the likely value of the intervention proportionate to the time, cost, and risk involved? And like that last point is particularly important because, you know, we don't see it as just another advocacy opportunity. It needs to be focused, relevant, and genuinely helpful to the court. There are like barriers and risks to doing it, particularly following some changes to the cost rules in the High Court bill. But actually, some of the issues start before we even get there, in that it's sometimes quite difficult to identify what cases we should intervene in. And conversely, sometimes we're asked to intervene in lots of cases and we have to say no. So how do we choose the cases or find the cases to intervene in? We follow cases that are of interest to us that are going through the court. But we also depend on our networks of lawyers, litigants, and other organisations to bring to our attention what is going on and where there might be something that relates to justice's work. Yeah, as I mentioned, there is a potential cost risk to intervening, although we do seek undertakings from the parties that they won't pursue us for costs. Claimants tend to give them, governments tend not to give them, but we have not ever been pursued for costs before, and we sort of take the approach that if the court has granted us permission, they are likely to find the intervention helpful, otherwise they wouldn't have granted us permission, and therefore we are unlikely to have costs awarded against us. I thought I would just take you through a couple of examples of recent interventions we've done. Some have been more successful than others. I'll start with the case of U3, which was a deprivation of citizenship case. And this sort of goes to the heart of what justice is about, the sort of fair administration of justice in circumstances where the impact of the decision is one of the most fundamental impacts that you can have, being deprived of one's citizenship. And also in an area that we're coming on to talk to later that is sort of least justiciable in relation to national security. So this case followed the Shamima Begum case, and it was about the role of SIAC, the Special Immigration Appeals Commission, that's the first instance court in these cases, and what type of review that it should conduct. In the first instance, the court had found, the SIAC had found that it's essentially limited itself to a judicial review type review. But we argued that it should have a broader remit than that, and have a fact-finding remit, and then should also be able to make use of those findings of fact, not only in circumstances where they find that the Home Secretary of State's decision is irrational, but in broader circumstances. And what our intervention basically focused on was the history of SIAC, sort of going all the way back to the 1900s and the supervisory jurisdiction of courts since the denaturalization of aliens legislation. So from that through to the Three Wise Men process, and then the creation of SIAC and what the original function and it was meant to set up to do. We were not particularly successful in that case. The outcome was, I guess on the plus side, I should also say this went to the Court of Appeal and the Supreme Court, so we intervened in both of those cases. On the plus side, both the Supreme Court found that appeals could be based on evidence that was not before the decision maker at the time, which is really important because when these deprivation of appeals happen, the person whose citizenship is being deprived does not have an opportunity to put their case before they're being deprived. So it's really important that they can put before SIAC new evidence before they make in their appeal. On the downside, the Supreme Court found that the jurisdiction of SIAC is essentially limited to a judicial review jurisdiction, ordinary judicial review jurisdiction. Another case in which we were more successful was a very discrete issue. It's called IAB, and it was about the redaction of civil servants' names in judicial review proceedings. The reason we were interested in it was because our work on open justice and duty of candor in judicial review proceedings, and the importance actually of context. And we argued that the context, the names of people are particularly important for understanding the context in which a decision was made. And we were successful in arguing that case. And I have some friends that work in the civil service, and they will really hate that decision because all their names now have to be, well, not all of them, but yeah, so more at risk of their names being disclosed. So I don't think we are much liked within the civil service for that one. But we thought it was an important open justice point. The last one I just wanted to touch on also touches on protest rights in the remaining couple of minutes. And this was a referral from Northern Ireland on a piece of legislation that was putting in place abortion safe zones, so areas around abortion clinics where you could not protest. And the question was whether this was compatible with Articles 10 and 11 of the Convention. And this was an instance in where we identified that there was a point not being argued by any of the parties, or well, the parties and the multiple other interveners in that case. So what was put before the court was a binary choice. The legislation didn't have a reasonable excuse defence in it, and the choice was either this was human rights compliant without the reasonable excuse defence, or it was not human rights compliant because it lacked the reasonable excuse defence. Our argument was that it was human rights compliant. You didn't need a reasonable excuse defence because we said that the criminal courts have a duty to consider the Article 10 and 11 rights of defendants when they come before them and are being prosecuted on a case-by-case basis. We lost that case, and I think we thought about this quite a lot tactically before we intervened about whether we should be putting forward this argument. Clearly, it wasn't being put forward by any of the other parties, but we also knew that there was a risk that we would get an adverse finding on that issue. And I think that was quite finely balanced. In the end, we did decide to go ahead with it, and we did get an reasonably adverse finding on it. So yeah, I just some lesson learning about whether that was worth doing or not, and thinking about that before intervening in other cases. And thank you.
Thank you for some fascinating, extremely insightful presentation to some of the some of the challenges in running this kind of litigation. I've got several questions. I'm sure some people in the audience do as well. On the first, in terms of the GLO glow up revamp, I should disclose that I'd given an expert report in a video case about the operation of 19.8 as it now is, and it's obviously a matter for court how it treats that evidence, of course. But what struck me in that case, and it struck me in other mass tort complex claims, is that, of whatever kind, to be honest, is that English judges are very, very attached to their case management flexibility, and they see any kind of structure imposed upon that as somehow limiting what they can do and hamstringing them. And I'm not sure what comes first, because in the NVIDIA case, for example, and this is perhaps as a reflection of what's happening in the Mariana case, the court's instinct is to try and recognise that there's an access to justice issue in terms of allowing this forum for claimants to pursue their claims, but they're also keen to provide defendants with something on the other side, right? So to mediate claimant and defendant interests, right, by providing them with particulars and things like that, and sort of balance the interests up against each other. And I think what gets lost is that, certainly from a Antipodean perspective, from the colonies, is that when you have proper collective redress frameworks, it focuses the judge's mind on their overarching role, which is to the public interest, and resolving common questions with common answers, which then leads to a sort of bifurcated structure of dealing with common questions first and then follow on. Would you go so far as to say a complete revamp, a class action system? Would you recommend that? Because the other thing I've noticed is that the practitioners in this jurisdiction just get used to what they're familiar with and quite like the informality of GLOs and the flexibility that goes with it. So that's a question for Russell. In terms of, for the other, I mean, all power to your hand, Richard, but sort of following on from also Alice's presentation, there is sometimes a risk that when you bring these cases, you can go backwards as well as forwards, right? So that the cases can be, important precedents can be narrowed. I mean, I would hope the South African court doesn't narrow Vedanta, but it wouldn't surprise me if Vedanta got narrowed or distinguished in this jurisdiction at some point in the future. Hopefully not, but that's a risk. So just in terms of the calculus of pushing it forward, perhaps going backwards, and in terms for the client's interests or in terms of the broader cause, to both of you, and obviously Stephanie as well, in terms of what is the calculus? Like, when do you press go, and when do you say perhaps we should do something different, or wait till, or be more cautious in our approach? Is it, yeah, have the
already turned on? You hear me? Yeah. It's a tricky question, I think, Andrew. I mean, I think obviously one can't be a sort of claimant zealot about these sorts of things, and plainly a defendant is entitled to know the quantum of the claim that they face and so on, and the court will want to know that at an early stage in order to manage the case in any proportionate way. But it just does seem to me that, you know, those are sort of extreme ends of the scale, whether you provide the full class action procedure or a high degree of specificity for pleading of losses and so on, that's required at the moment or envisaged at the moment. And it does front load the time, effort and resources to an enormous extent. And in cases where, and obviously one also has to be cognizant of some of the risks that we've heard from the states, where we obviously want to ensure that there's no fraud, that bad claims are weeded out, that they are genuine claimants and so on and so forth. So those are all hugely important considerations. But on the other hand, you know, there are cases where you can plainly see that there are large numbers of claimants who have suffered substantial damages and entitled to claim. And you can also plainly see that the defendants are going to take preliminary points. And so the point I was just floating is whether there is some way, some sort of hybrid structure. I haven't alighted upon what the solution would be in order to allow those plainly meritorious claims, at least on their face and after a disaster, say, to proceed without having to spend quite so much money and front load quite so much time and resource to get the claim off the ground. I was interested listening to Richard discussing the cabway litigation. For example, if a case like that was to be brought here, you would face issues like, well, it's a personal injury claim. Do you need, the default position would be expert report appended to a schedule of loss. Yes, you can get dispensation from that. But if it's a blood poisoning case, I mean, how do you actually prove that in each of the cases? Are you having to go out and perform blood tests on thousands and thousands of people and every individual before they can actually bring a claim, before they can prove the loss that they want to bring? So it's tricky, but I think I'm just sort of posing a problem at the moment rather than offering a solution.
I think the cabway case is probably not a good example to illustrate that point, because the magnitude of it is such that it would have attracted litigation funding in this country too. And so, although it would have been incredibly burdensome to do with that kind of level of work that you mentioned, it would have been possible to do it because the funding would have been available. The difficulty really is with the smaller public interest cases, where, especially if they're of the international variety, you're dealing with damages which, under the Rome II regulation, are based on local levels, so that the value of claims is much less. And if you've got a smaller number of claimants, then these cases are not attractive to litigation funders. And we've come across many cases which have been litigated, which it has been possible to litigate in other jurisdictions where they have opt-out regimes that we haven't been able to do. Vioxx many years ago, I was in Australia for a few years, and we started the Vioxx litigation. Vioxx was an anti-arthritic drug which was alleged to have caused heart attacks and strokes. That was done on an opt-out basis in Australia. It wasn't possible to do it here, a smaller case, a smaller cabway type case, would not be possible to do here either on an opt-in basis. Just on your point, Andrew, about making bad law, I guess I'll say the opposite of what I'm just saying now, where I'm kind of emphasising the importance of public interest over defendants' interests, effectively. I think when we take on a case and we're representing individuals, we have to act in their best interests. And that's our job, is to do what is best for them. And sometimes, yes, that you run the risk of making bad law, because you can't pick and choose necessarily what cases you do. It depends on who you happen to be representing. Fortunately, that hasn't happened very often, but it does sometimes happen.
I had pretty much the same answer in mind. In judicial review, creating bad law is a constant risk because you are discussing the law, and there is a potential for that to be an area where the interests of the lawyer and client aren't necessarily aligned, because it's not always forefront in a client's mind what the impact would be on the law of them pursuing a particular point. But I do find that tends to actually dissolve when you fully discuss it with the client, and in fact they are challenging that issue because they care about it, and they won't necessarily want to run bad points if there's a risk that they will make the situation worse in the future. So it's a question of discussion.
Well, unlike you guys, I don't have that issue because we are the client. So we can take, and we're also lawyers. So I think, we understand and we can pick and choose which cases we apply to intervene in, at least. So we can take that sort of very strategic approach. But yeah, sometimes as with the abortion safe access zones case, that's quite finely balanced, and we have to make a decision. I think in that case, the context in which it was happening anyway meant that if we didn't argue it was going to happen soon enough in any event, and we thought that it was a point that should be before the courts.
Thank you. I'm going to open up to questions. If anyone has any questions, Az.
So long. By some redress, helpful redress in your case, to this for Zambian victims. You mentioned factors about the concern for Black lives. And I was wondering whether a similar consideration contributed to the failure of the Al-Haq case.
You did that, mate, and you can.
To be honest, I don't think that was a reason for failure. I mean, there's lots of related issues, but just focusing on narrowly why the court found against us, I think a large part of it was those mischaracterizations, so misunderstanding about whether the case was about demanding that the court come to a view on Israel's conduct in Gaza, rather than asking the government to look again at its own decision making. And so that there is obviously an element in that, in discussing the situation in Gaza and the conduct of Israel there annoyed the court. But I think that was more because it was plain to them, and they felt should have been plain to us, that those issues weren't relevant to the legal grounds. We knew they weren't, but they were important context for our clients. So yes and no.
Exactly the answer I expect.
Other questions? Mustafa.
Justice sort of has this reputation of being universally respected across the political spectrum. Courts very happy to listen. In a way that's almost not the case for many other similarly placed organisations, rightly or wrongly, who are dismissed as sort of, they lost a political battle and now they're coming to the court to litigate some of those issues. What do you think justice has done which has cultivated that deception in the eyes of so many across parties, across courts, in a way that other organisations who do similar things might not do?
I think firstly, what I was going to say, I don't want this to sound. We're not a single cause organisation. We're not fighting for climate, against climate change. We're not fighting for a cause. We are fighting for the good administration of justice. So I think that's an issue that lots of people can get behind, whatever their views. We're also incredibly evidence-led. So we always back up everything we do with significant evidence, which helps as well. And in terms of interventions, we really do pick and choose the things that we apply to intervene in. We genuinely think that they are going to be helpful. We don't do it for reason of a particular cause. I think, and sometimes, and we don't do it just to support a party either. And we often, get approached to intervene in cases and say no a lot of the time for those reasons.
Lord Briggs.
Let me say how much sympathy I have in the grinding burdens of front-loading of group and collective actions that particularly Russell described, and the disincentive which those burdens impose on the prosecution of those types of claim, particularly where the numbers involved are perhaps just below the funding threshold. My question is this: are you looking at the availability of AI tools to streamline some of that grindingly expensive front-loading processes? And if so, if you can do it in a few seconds, which ones?
I mean, I don't know which ones people are looking at in my firm, because I'm not involved in the Dieselgate litigation, and those people have been, I think, looking into that quite carefully. But undoubtedly, we have no choice than to use AI tools, and that will result in considerable efficiencies and streamlining of work and staff reductions too, undoubtedly.
I mean, at the bar, I'm not involved in that directly. I have seen the sort of beginnings of the use of AI tools to populate questionnaires and so on, based on all the available data that a solicitor has on its file of their interactions with individual claimants. In the Mariana case, albeit this was 2018, the process started, so the tools have advanced considerably since then. But even then, tools were being used to prepare individual particulars of claim in a sort of drafted style, based on questionnaire data and information to try and speed up the process. But there is a fundamental tension that remains, it seems to me, that if the court is requiring that high level of individualized pleading of heads of loss with great degree of specificity at a very early stage, it's not easy to overcome that challenge through an AI tool. But for sure, I can see some progress being made on that front. As for the names of particular tools, I'll need to check.
I'm going to take the progress to ask the last question before tea. Coming back to the point you made, Russell, that one of the legitimate defendant interests in requiring these particulars is to get a scope on scale proportionality for the purposes of, in their mind, like the possibility of dispute resolution, of settlements. And I mean, I think that they too could engage in some sampling of those claimant rights to do it in a much more efficient, proportionate way. But just channeling defendant representative interests here, because they're not actually on the panel, a lot of them would say that whether it's in mass tort or in public law, that the court's not the right forum. That for example, in the Mariana case, there's a compensation scheme in Brazil that's been set up, and there's sums being made available. Or in public law cases, the appropriate forum is in the ballot box, or in other forums. So, just generally, does anyone have any observations about whether you think you're in the right forum to raise these questions, or it should be better dealt with elsewhere?
It depends. Was a lawyer's answer. But at the end of the day, a functioning civil justice system for the 21st century, I would suggest, means that the claimant should be entitled to go to court and access redress there if they feel that whatever alternative scheme has been set up for them isn't working for them. And so one does want, I would suggest, the sort of safety valve of access to a judge at the end of the day.
Yeah, and certainly in the kind of cases we do, access to a judicial remedy is essential. I mean, you can't rely on anything else to secure redress for victims. Regulators are often ineffective, criminal sanctions are not imposed, and you certainly couldn't depend on corporations to necessarily do the right thing, and they need to be held to account when they don't. I was going to mention something about the sampling point that you made earlier, because we had a very interesting example of how that could work a few years ago when we were trying to settle the gold miners' silicosis litigation, which was also happened to be in South Africa, and there were thousands of claimants, and it wouldn't have been feasible to examine them all in order for the defendant to get a handle on how much the claims might be worth. And so the way we approached it was to ask a statistician, what would a statistically significant sample, how many would you have to sample? And he said 115. And we then used a program to randomly select 115 people. They were all subjected to quite a rigorous medical evaluation. And by using that and scaling it up to the number of claimants, we came to a figure. And I can tell you that in the end, when people were applying for compensation under the settlement trust that was established, they had to go through the same medical process over a period of years. And the percentage who turned out to have lung disease was exactly the same. So, it was a very effective process. But I mean, that was a case where the disease was almost identical. Where you've got people with different types of injuries and losses, I think that's more difficult.
Much to add, the talks are really at the heart of everything that we do when we're running public law cases. Even when you settle outside court, it's with a view to what the parties feel that a court would do. And so the fact that there is the potential of a court at the end of that process is essential. Otherwise, there would be no reason for the parties to come together and discuss it. I can't see a better form myself.
Okay.
I think with public law litigation, ultimately, even though we're talking about, the wider impacts, there is an individual or individuals at the heart of it. And, the idea that they should wait 5 years for the ballot box to correct unlawful state action in their individual case, if that can even correct unlawful state action, I think, you need law to be able to do that. And obviously, in judicial review, we've got the commission stage, so if it's not the appropriate form, it doesn't get to the full hearing.
Right. I want to thank fantastic group of presentations from fantastic speakers and all right. Thank you, everyone. Let's get started. Welcome back. This particular session is essentially about the relationship between the administration of justice and external interests, in this case, national security. It's a niche public law topic, but a core procedure topic. What makes a trial fair, and what do we do when we can't do a fair trial? And we have there is no more qualified speaker on the planet, I think, to discuss this question than Mr. Justice Martin Chamberlain. He has experience of this topic from every perspective, as a special advocate, as a barrister for the excluded party, counsel for the excluded party in some cases, and now as a judge on many occasions. And we are delighted to get the benefit of his perspectives on this question, which have evolved slightly over the number of years in which we've had presentations from Mr. Justice Chamberlain on this question. So, without further ado, over to you, Martin. Do you want to come up to elect it? Yeah. Yeah.
Back, yeah. Well, thank you very much, Andrew, for the invitation to speak at this event. I've been coming to Oxford for quite a few years on and off to speak on this topic to BCL students. In fact, since shortly after I started work as a special advocate doing national security cases about 20 years ago. And I thought it might be worthwhile just to say a little bit about how my own views on this topic have evolved over the period when I've acted as special advocate, acted for excluded parties, and then as a judge in national security cases. My experience has covered quite a broad range of different types of national security proceedings. So I started off in 2002, so just after 9/11, when the Anti-Terrorism, Crime and Security Act had been passed to enable the detention of a number of individuals who were suspected of involvement in Islamist terrorism. And what the Act did was that it enabled the detention without trial of foreign nationals who could not be deported because it would breach the UK's human rights obligations to do so. And the appeal was to a body called SIAC, the Special Immigration Appeals Commission. And the main thing that SIAC had to determine was whether the allegations against the individuals were sufficiently well-founded to enable the Secretary of State to detain them. Now, I'm sure anyone who's looked at this will know that it didn't take very long for the House of Lords to say that the detention regime under the Anti-Terrorism, Crime and Security Act was unlawful. It was in breach of Articles 14 and 5 of the ECHR. And we then had the replacement regimes, which were control orders and later TPIMs. And those were closed material procedure cases which came to the High Court rather than to a specialist tribunal. And I was a special advocate in many of those cases as well. Now, I've set out my views on this in a series of articles from, I think, 2009 or 10 onwards. And I can summarize the views that I set out there as saying that the special advocate system, that's to say that the system of having a security cleared lawyer who gets to see the closed material when the excluded party does not, was presented as making procedures which would otherwise not be fair by the standards of the common law into something that resembled fair proceedings by common law standards. And my view, which I set out over a series of articles, was that they did not do that, so that the proceedings were not fair. And one of the main reasons why they were not fair was because a principal objective of the proceedings was to try and work out whether there was a case against the individual who was suspected of terrorism. But the difficulty that the special advocate had was that whilst the special advocate got to see the closed material which implicated the individual, the special advocate couldn't then put to the individual, well, you see, they're saying that you went to a terrorist training camp between these dates. Did you or didn't you? Because that was closed material, and to reveal that to the individual would itself be contrary to national security. So it seemed to me that the proceedings were not fair, and the use of special advocates did not make them fair. Now, the view that I expressed there was not, I was quite careful not to say that the procedures were not justified. It was simply to say that they were not fair. Why is that? Well, because fairness was one desideratum, and there were other desiderata such as safety and national security, and it was a matter for the legislature to decide how to balance those two considerations. And that was a view that I've expressed along with some of my colleagues who were also special advocates to various parliamentary committees. And it's all, if anyone's interested, all gathered in an article which I wrote in 2018 in the University of Toronto Law Journal. So all the sources are there. So how has my view changed? Well, there are a couple of cases which I did late on in my career as a barrister, not a special advocate, in fact, but on both occasions as what I'd call a normal advocate, as it were, which changed my view a little bit about the value of closed material procedures. I've skipped over, by the way, the debate about the Justice and Security Act. I was a participant in that debate and an opponent of the Act at the time, and I'm not, I think, saying anything that you won't be able to find from the published sources by telling you that. But there's a couple of cases which I did late on in my career which I think did change the way that I see these procedures. One was a case called Haralambous in the St Albans Crown Court. And in that case, I was leading counsel for the police, the Chief Constable of Hertfordshire, I think it was. And it was a challenge by a claimant to a decision by the magistrate to issue a search warrant under PACE. So a pretty standard search warrant issued under the Police and Criminal Evidence Act. The application to the magistrate, as many are, was made ex parte, and it relied on sensitive material. But a procedure had grown up by which, if you wanted to challenge the warrant, you could ask subsequently for disclosure of the material on which it was based. And the magistrate said, no, I can't show you that material because it's sensitive. So the question in the case was whether on an application for judicial review of the magistrate's decision, the High Court could look at that material or not. The case law, Al-Rawi is the main case, Supreme Court case from 2012, decides that generally speaking, to have a closed material procedure, it's such an incursion into natural justice that a statutory authority is required. There was no statutory authority. This was a criminal cause or matter. So it was not covered by the Justice and Security Act. So there was no statutory power to hold a closed material procedure. Nonetheless, the case that I argued for, and which the House of Lords, which the Supreme Court rather accepted, was that one would have to devise at common law a closed material procedure, because if you didn't, how was the claimant ever going to achieve any kind of independent scrutiny of the warrant? Essentially, what was going to happen if there was no closed material procedure is that the claim would simply fail. Why? Because you wouldn't be able to see what material had been before the magistrate, and therefore you wouldn't be able to tell whether what the magistrate had done with it was flawed in a public law sense. Now, the second case, which I think picks up the same theme, was Campaign Against Arms Trade and the Secretary of State for Trade, and this was in 2019. I think you had some discussion, so I understand, earlier about the Al-Haq case. Well, this was a predecessor of that case, and it was a challenge to the UK government's decision not to suspend export authorisations for arms exports to Saudi Arabia, on this occasion not Israel, but Saudi Arabia. And I was counsel on that occasion for the claimant, Campaign Against Arms Trade. And the claim was that the decision was contrary to the Secretary of State's policy that arms exports will not be permitted where there's a clear risk that the arms would be used to commit serious violations of international humanitarian law. We had a claim that was based on open source reporting. So we were relying on reports from people like Amnesty, Human Rights Watch, and from various UN panels which had looked at the conduct of the war in Yemen. And of course, we knew from the outset that there was bound to be, in addition to this open source material, closed material, which was available to the government, which enabled it possibly to reach a different view of whether particular strikes, we were looking at strikes on hospitals, strikes on schools, on weddings, and all kinds of things like that, were or were not contrary to international humanitarian law. Now, if you didn't have a closed material procedure in a case like that, how could the court respond? Well, the answer is that if you didn't have a closed material procedure, you would be left with the open source reporting. And again, I suppose my perspective as a judge confirms this, but you would be thinking, well, what else might there be that informed the government's decision that the relevant threshold was not met? So we were very keen that there should be a closed material procedure. We were the excluded party. Obviously, I don't know to this day what went into the closed material procedure. I've never seen the closed material. But I do know that we had a very excellent special advocate representing us in the closed material procedure, Angus McCulloch, QC as he then was, and that the court would be able, through the use of a closed material procedure, to interrogate that material and to see whether it really was material that would change the complexion of the case in the way that the government said. And the answer eventually from the Court of Appeal was no, it didn't. The result was that the export authorizations were quashed, and for a period of, I think, coming up for 2 years, there were no arms exports from the United Kingdom to Saudi Arabia. Now, that's an example, I think, of a case, and I've seen quite a lot of other examples as a judge, particularly in judicial review cases, where if you didn't have a closed material procedure, there really would be no way of testing the government's claim that the decision that they've made is based only in part on open material and partly on closed material. So I think that those two cases have impacted on my views about the utility and the necessity for closed material procedures. I'm going to stop there because I think I've taken more than my 10 minutes. I'm going to hand over to Shaurya, who's going to say a few more, I think, practical and theoretical things about closed material procedures.
Thank you very much, Mark. All of these conferences have to have an up-and-comer, and the up-and-comer in this case is my DPhil student, Jara Apadi, who's in a former life was a professor at Jindal Law School in Delhi. He's now doing a doctorate with me at this issue of closed material proceedings, all aspects of it, from the doctrine to the policy questions, and he's going to present his thoughts or essentially his thesis in miniature form now.
Thank you so much, Andrew, also for the opportunity. You can trust Andrew to put you in a room with every single person you're citing in your DPhil in any relevant form and go, yeah, defend it in front of them now. Thank you so much. Actually, where Martin leaves his presentation is exactly where I want to start from, which is this idea that the judicial process is this search for the truth, and we need access to every single element of evidence before we can make a decision as a judge. And that's definitely a judicial sort of inclination that a lot of evidence scholars have sort of talked about. And we have scholars, and of course you can trust the academic to come up with, like, start with legal philosophy. But we've got evidence law philosophers who talk about how the search for truth is not the purpose of evidence law. It is the purpose of doing justice within which evidence forms one of the prongs. And I'm quoting Ho Hock Lai here in his work on evidence law. Absolutely stellar work, which has sort of guided me on how and what should be the balances struck between fairness and the search for truth versus justice in its procedural form, and doing sort of like looking at the claimant through a dignitarian lens. So I'm going to start with sort of the Al-Rawi point, and essentially how Al-Rawi goes ahead and says, vehemently opposes the idea, and a lot of observations from the case at CMPs as anything that we can order. But more importantly, some of the observations go on to claim that CMPs as a mode of doing sort of justice simply does not meet the common law threshold of procedural justice in the first place. And how I've structured my presentation is that I first go into the requirement aspect. The idea that CMPs might be necessary, and these are exactly the committees that Martin talked about, I've gone through a lot of the work done by these committees. Justice was one of the interveners in a lot of the initial green papers that these committees have published. And the conclusion drawn by the Joint Committee on Human Rights was, and if I may quote, they found it very hard to reach an evidence-based view as to the likelihood of this theoretical possibility of essentially these kind of claims emerging. At that point, if I'm not mistaken, the government had said there are 27 cases before courts which require CMPs. And the Joint Human Rights Committee essentially goes ahead, it's the parliamentary committee says, well, this seems to be more like the government want CMPs rather than PIIs to happen in those cases, but they at no point in time disclose that these 27 cases are actually cases where CMPs are absolutely necessary. Would they lead to more evidence being there in trial? Surely. But would they mean that these are cases where justice requires there to be CMPs with a different threshold? And the committee eventually found that there was simply not enough empirical evidence to go on the basis of which they could say that CMPs were a requirement. But we see the intention of the government from a lot of their initial work, right? We see the first green paper which was sort of floated by the government, where they made out the case for CMP actually replacing PIIs. And it was very clear from the get-go that that was the intention with which the government floats the process of sort of expanding CMPs to civil claims under the Justice and Security Act. Essentially, we've reached a point where, of course, all of the need sort of is are CMPs required, as the debates become null, because we've pretty much, the UK has pretty much married itself to the idea of CMPs. When Justice Ousley's report was being formulated, there was a clear bar on going into any questions of whether CMPs are still required or has an empirical case been made out, and it was restricted to the efficiencies of CMPs as they put forward, and only that was sort of being discussed, and that is being discussed now with the government responses in 2024 with sort of improvement protocols, and they're coming up with more advice on that. But essentially, there are three framings, and I think the reason I'm going into this question at all at this point is that the common law, especially English common law, remains influential across jurisdictions when it comes to evolving procedures, when it comes to sort of other countries emulating common law procedures on such matters. And recently, a lot of this became topical in India, where we were struggling with our own issues regarding whether to go into something like what they call the sealed cover with amicus proceedings. And it was patently rejected as the primary or any mode of going forward with litigation by the Supreme Court in India. And the reason they do so is the structuring of fairness. And this is where it comes, where I sort of come to my second point on what is this fairness that we talk about. There are three constructions of fairness that have essentialized discussions around CMPs too. Sorry, I am rushing, but I have I prepared, I don't know, I think this is a 1 hour lecture at this point. Three framings of CMPs. A, are CMPs as fair as an open trial? Nobody would say they are. The second formulation, do CMPs meet the common law threshold? I.e., do they meet certain absolutely, sort of essential standards of due process that cannot be let go of when designing procedure? And that's where most of the debate on fairness sort of substantively happens. And the third issue, which is, in some cases, could CMPs sort of provide the sense of fairness that other procedures might not? And these three formulations of fairness are each distinct debates, which are often muddled within academic commentary in order to lead to very sort of confusing conclusions. And untangling them has been a fairly large process. But what I would say is, when reading judicial statements, they usually allude to the common law standard of fairness. And my conclusion after reading most of the material out there is that the common law standard of fairness is something that these proceedings simply do not meet. And I'm sure Professor Zuckerman would agree, because I hope he still does, because I've cited him a bit on this matter. But on the issue of this simply being a proceeding that does not meet the requisite standard of fairness set under the common law. And I mean, I could go into that. I've got like several quotes. You've got one of my favorites is Lord Kerr's statement from Al-Rawi. But I'll go into the one statement made by the Indian courts on the nature, the epistemic problem with, and this is one of the biggest problems I see with CMPs. The issue with CMPs is not that more evidence is good, but whether unchallenged evidence, unchallenged not by special advocates, and as Martin alluded, the special advocates did pose a very sort of elaborate challenge to the fairness of the proceedings during the sort of the committee consultations. But does unchallenged evidence lead to better somehow meritorious sort of decision making? And the statement I would like to say that, so the statement I really like, this is from Justice Chandrachud at the Supreme Court in India. He says, it must be recognized that the court could be misled by the material that is not subject to inspection and examination. This would lead to a situation where the court renders an unfair judgment, and such an unfair decision would not be amenable to both judicial review and public criticism on its merits. So essentially, sort of a closed judgment, thank you, a closed judgment where the evidence has not been scrutinized by the claimants or their lawyers, essentially leads to a problem with this knowledge gap, this misleading nature of the evidence is where I believe the fairness debate finally, on the common law threshold, finally turns. And that, I believe, is something that has remained unchallenged. I do think that poses a fairly large challenge to the fairness assumption within CMPs. Now, there is always, it's this sort of argument that goes with a lot of philosophical concepts that I think somewhere everyone does acknowledge are indefensible, which is, but there's no better alternative, right? And that's essentially what my project aims to look at. Are there reasonable alternatives that we can go for, which instead of CMPs? And what I've proposed, and these are essentially two proposals. None of them are very novel, but they have been discarded several years ago. One, of course, is this sort of adverse inferences pathway. The idea that if you don't have the evidence, or if the government can't lead the evidence, and if on a PII balance, a whole other sort of procedural mechanism that I haven't gone into yet, but on a PII balance, if there is absolutely a need for that evidence to be there, there must simply be an adverse inference drawn, or essentially a mandatory disclosure followed by an adverse inference. And this was essentially what the Green Paper, the initial intention of the government, was very clearly sort of based on, right? They knew that if there were adverse inferences, the government would have to settle in a lot of cases. And that's the assumption they start with, that settling these matters, when the government and the judiciary cannot provide any reasonable sort of remedies to the claimants, at that stage the government's forced to settle, and that's simply unacceptable. My project aims to challenge this assumption within the government's stance, i.e., if the government and the judiciary cannot provide for remedies, they must simply settle, and they must settle. There are various mechanisms of settling which can be taken up by parties, and I'm trying to devise that through my project. But essentially, that's my 2 cents on where I think that the fairness debate should be going, and where at least jurisdictions that are now evolving this law should be taking this debate rather than towards fairness. Thank you so much.
Thank you. I've got a couple of questions I'm going to open up first, and then before I open up to the floor. First to Martin, in terms of the experience in the campaign against arms trade case. I think we can all see from a campaigning group's perspective the attractions of being able to put forward, get evidence before a reviewing court that would otherwise be inaccessible to them in circumstances where the claim would simply not be reviewable without that information. But is it quarterly different when it's the person who has to make that choice is the person whose rights are being affected, where they've got a PII process where they're bound to lose, to use the vernacular, or take the ultimate lucky dip with a CMP where they don't even know what their prospects of success are, and they're using extremely unreliable proxies like do I have Martin Chamberlain as a special advocate or Angus McCulloch? And is that a defensible choice to impose on non-state parties? And I say that relatedly because there's a very interesting decision of the High Court of Australia where, because we had a different constitutional framework, we can't just point to legislation and say Parliament willed it, therefore it's law. But what the High Court said by a narrow majority was that provided a party has the choice between a traditional adversarial process with PII and, on the other hand, a CMP where they would have access, someone would have access to the evidence, but not them. So long as they have that choice, then there can be no there can be no unfairness, because any unfairness is the product of their own procedural choices. So, just your thoughts on that.
Well, picking up a point that Shorian made about common law standards of fairness, the common law hasn't actually been a very useful tool in the development of the law on closed material procedures to date. And that's because, well, the common law has told us you can't have one unless you have a statutory authority. That's our RAWI, subject to a caveat, see Harold Lambers. But that's really all it's told us. All the work in terms of when might it be fair to have a closed material procedure, in what circumstances are special advocates going to be enough, has been done actually in the context of Article 6, not in the context of Articles 5 and 6, not in the context of the common law. So there's actually now quite a rich jurisprudence, both at the Strasbourg level and in the domestic, especially in the domestic courts, which works out in what sorts of cases is a special advocate going to be enough. In what sorts of cases do you need something more? Like, for example, the requirement that the government disclose at least the essence of the case against you. And I'm not sure that that case law, I gave a judgment actually last month trying to make sense of some of that case law, maybe without a great deal of success. But one way that you can look at it, I think, is that there's a difference between cases where the challenge to the other side's evidence is within the system of the other side's evidence, if I can put it that way, and cases where the challenge comes from evidence that you yourself want to adduce. Now, the public law paradigm is very much the first, because in general, in a public law case, what you're asking is whether the reasons that the public authority had for the decision that it made are adequate reasons. And that's something you can tell just by looking at the reasons. You can look at the reasons, whether they're open or closed, and critique those reasons and say, well, actually, there was a logical gap here, as we showed in the campaign against arms trade case, and the other side can defend it by reference again to that same material. And I think in a case like that, it probably is sufficient for you, largely sufficient, to have a special advocate looking after your interests. Why? Because the material is there, a lawyer looks at it, makes what submissions they can. Why does it matter whether it's that lawyer or this lawyer? The difficulty comes in cases, and the cases where people were detained or subject to restrictions on liberty on the basis of suspicions that they were terrorists. Those sorts of cases are very different, because the challenge to the case doesn't just come from the reasons, it doesn't come from looking at the reasons and seeing whether they were good enough. It comes potentially from the ability of the individual to say, no, I wasn't at that terrorist training camp. I was somewhere else, and here's the evidence. And of course, you can't put that evidence in if you don't know what the allegation against you is. So I think there is a difference between different types of case, and the balance between fairness and national security falls perhaps to be struck in a different way, depending on what kind of case you're dealing with.
Right. Questions? Do we have any questions? Cool.
Question for Mr. Justice Chamberlain. You mentioned some situations where the court would go on to determine a case on the merits and the applicant would fail, and so that justifies the unfairness of the CMP. Have you encountered any cases, or do you have any views on a case where the issue would be rendered untriable, so a Carnduff and Rock style situation?
Well, so one of the points we made when the Justice and Security Bill was going through Parliament was that Carnduff and Rock was being touted as if it were some very well-established proposition, whereas in fact it was a couple of throwaway lines of law justice laws in one case in the Court of Appeal on quite extreme facts. That was essentially what we said to answer that point when the bill was going through Parliament. I think a better case is a case called AHK, which was the first instance judgment of Mr. Justice Ousley in around about the same time, I think 2012. And it was to do with, it was a public law case where someone had challenged a decision to strip them of their British citizenship. And the Secretary of State's reasons were, well, for reasons of national security, we've decided to strip you of your citizenship. We can't tell you what the reasons are. I mean, how do you even begin to deal with that if you haven't got a closed material procedure? There's no basis. If there were no closed material procedure, the Secretary of State would simply claim PII in respect of the reasons for the challenge decision. And let's just assume for the moment that the PII application succeeds because there are genuine reasons of national security not to reveal what the reasons are. Well, that's the end of the case. As far as the claimant is concerned, you can't establish there's anything wrong with that decision, because once the PII certificate has been upheld, the material is then completely inadmissible for either side. So you've got to have, in a way, in a case of that sort, you've got to have some way of getting your hands on the reasons. Now the disbenefit, as you might call it, of a closed material procedure is, of course, that the individual won't get to see the reasons. But it's better than simply having no ability to challenge the decision at all.
As
I just like to say, last one, the decision will be given to an individual, and his case or her case may be dismissed for reasons we can't tell you. And that's the end of the decision process. If you think that's satisfactory, maybe it's if you think this is satisfactory, well, so be it.
I've asked this question to you before, but for the benefit of my students who are doing revision to the exam, on the scope of the AF number 3 gist, yeah. So if you were one of the judges in Tariq, what would you have said about the scope of that gist when it's required?
Do you mean when does AF number 3 apply?
Yeah, exactly.
Okay. So well, that's one of the things I tried to unpack a little bit in the judgment I gave last month. I mean, I think that Tariq is best understood as driven by a set of policy considerations about security vetting. So security vetting is a process that, it's a process that anybody who's been a special advocate has to go through. It's a pretty unpleasant process because they ask a number of a very large number of extremely intrusive questions and pour over your bank statements and medical history and all the rest of it. But if you decide to put yourself forward for security vetting, then you know the deal. The deal is that they will ask all those questions, and they will also look at material which you won't know about, which they might have, which relates to you, and they will either decide to give you the thumbs up or the thumbs down. And that's the deal. If you get refused security vetting, then you can't do a certain number of jobs which require it. But there's not that many jobs that require it. You're not being turfed out of the workforce altogether. And so I think that Tariq is best understood, and then a number of other cases in the Court of Appeal as well, which deal with closed material procedures in that context. Where I think the justice of the case is, well, sorry, but you signed up for this process. You knew that the government were going to look at a whole bunch of secret information about you, and you knew that the consequence, the result of it all, might be thumbs up or thumbs down. You don't now have a right, just because you brought a claim alleging, let's say, discrimination, some other wrong in the conduct of your vetting application, to see the secret material which you always knew they were going to look at and was not going to be shown to you. So I mean, I think to my mind, that's the actual reason behind Tariq. I mean, the various judgments don't all expressly rely exclusively on that point, but I think that's the key to it.
Okay, and so does that, by extension, outside those contract, so agreement situation with the state where you submit yourself to this process, do you think that AF number 3 just should apply outside those situations?
Well,
even regardless of whether liberty is at stake.
I mean, I've seen. So I was also special advocate in Bank Mellat, which was another case where AF number 3 was held to apply, and that was a case about an Iranian bank which was challenging sanctions on it. And one can see the logic of the ruling that AF number 3 does, that the requirement to give an essential gist does apply in that context, because what was being done to the bank was, if you transpose restrictions on liberty, the seriousness of a restriction on liberty vis-a-vis a person to a legal person such as a bank, well, what was being done to the bank was as serious as a restriction on liberty, as it were. £200 million in call accounts were basically frozen and all the rest of it. So I think, I mean, I can see a basis for a sliding scale where AF number 3 applies in some cases, but not in others. But you'll see from my last month judgment, I think the sliding scale yields a binary answer. Either it does apply or it doesn't apply. At the moment, I find it very difficult to understand what a sliding scale would look like if it applied a bit. I could put it that way.
Okay, great. Thank you. We are going to move on to the next session, but I want to thank both presenters for fabulous insights into fundamental questions.
No, not.
Oh.
You can just drag it to the desktop.
Okay. You want to excellent.
Right.
My phone is okay. My phone is this now. And like what's going?
No, I don't mind.
Yeah, with you.
No, but I've got to. Okay.
Yeah.
What have you got?
Okay, so now, thank you everyone. Now we're going to move to a session on ADR, and we're going to explore its place in the system, but also the value of ADR in and of itself, using both old and new technologies, but also what the civil justice system itself can learn from innovative ADR approaches. And our first speaker is Professor Adrian Zuckerman. He quite literally needs no introduction. He is essentially just, as I said, the North Star for everyone working in this field, in my view. If you say something that Adrian Zuckerman will not endorse, you sort of have to stop and wonder how you got there, because something's probably gone wrong along the journey. But so with that introduction, I'm going to hand straight over to Adrian.
Thank you very much for your generous and untruthful introduction. I'm here to talk about access to justice, which is one of the themes here. We have talked about the great progress that has been made in collective redress, the great progress that has been made in human rights litigation. But I want to come back to the lack of progress that has been made for litigation of ordinary civil cases. And it was brought back to me the other day when a neighbor of mine, an electrician, came to me and said, what would you advise me to do? I've got an £18,000 claim against a client who wouldn't pay. I said, go to a lawyer. He went to a lawyer. The lawyer said, it might cost you 5,000 or 50,000 or 100,000. We don't know. Obviously, these people with claims of anything between, unless they are large corporations, they can go to court only by risking the roof over their heads, because the cost of litigation in England is uncapped and unforeseeable. And the purpose of the Wolf reforms and the Jackson's reforms were to bring down the cost of litigation, to enable ordinary litigants to have access to justice. They have completely failed to do so, as we all know, and the government has no interest. There are no votes in it. And ADR, as we know it, is it's very helpful, but not a solution. However, what offers a solution is technology. AI, about which Lord Briggs is going to address. I thought about it, and it has its limitation. And the main limitation of AI is that we simply can't keep up with it, and we don't know where it's going, and what it's going to do. But there are, fortunately or unfortunately, as you may realize in a minute, areas of litigation which have no access to court in principle. And they have no access to court in principle because they deal with unlawful things like arms, drugs, human trafficking, the dark web. And transactions on the dark web involve large sums of money, and people need a dispute resolution system, because a dispute in any kind of field can arise. You know, you've sent too few arms, or the drugs are not of marketable quality. How do they resolve this? And there are ways of resolving these disputes which are emerging now, which are reliable
and which don't cost a lot of money. And I want to draw attention to one of them, and that is called Claros. Claros is a French organization which provides dispute resolution service for people like those on the dark web. Well, transactions on the dark web are conducted by means of a blockchain. And they are conducted by means of blockchain because only blockchain provides anonymity. The people, in the criminal field, the more anonymity, the better. It's not like in the legal field, the anonymity we were discussing earlier. We want complete anonymity. That is to say, the parties of the contract don't know each other and therefore can't incriminate each other. But they need, when large amounts of money are involved, they need dispute resolution. So they go to Claros. Claros is nominated dispute resolution in the smart contracts. They don't have a problem about enforcement because the money is paid into escrow. And unless it is released on the word of the buyer or the dispute resolution, it can't go. There is no cheating. There is no cheating on the dark web. And so there is a dispute. The dispute takes place in this way. Claros will recruit, say, 12 jurors. I can't remember the numbers, the number different between different kind of areas. 12 jurors. To become a juror, you have to deposit a substantial amount of bitcoins. Once you become a juror, of course, there is complete anonymity. The jurors don't know each other. They don't know the parties. They can't communicate with anybody. The jurors are then presented with the evidence by the parties, and they decide. Decision is by majority. If you are in the majority, you recover your bitcoins and the bitcoins of the people in the minority, as well as the fees which are agreed in advance, which are part of the cost of running this business. So there is an incentive for people to be in a majority. The people don't care about the truth. They care about their investment. They've got, as Professor Sakharov said earlier, a skin in the game. And to make sure that they are in the majority, they've got to imagine how other people will decide. But they don't know the other people. They don't know anybody. The only way they can imagine increase the probability of being with the majority as the other people will decide is decide according to the evidence, because that's the only reliable factors that they have. And it appears to work. So I'm saying, and that's the purpose, offering it as something to think about. What I'm saying is, since the governments, not just in our country, but in the entire Western, well, certainly in Europe, in Western Europe, there are problems of delivering a dispute resolution service in the entire continent of Western Europe, either because, as in England, the cost of litigation is unaffordable, or as in Europe, the delays and maybe other factors. Maybe we should start looking at systems and institutions and device institutions that don't depend on public funding, that are inherently safe as an alternative for providing access to justice to ordinary people who can't afford otherwise court access. Now, I'm not saying that this particular system, which will be addressed in more detail later, I'm not saying that it is appropriate for every kind of dispute. I'm not sure it provides an alternative to closed material proceedings, but it can
is something we need to start thinking, and that's my message. We need to start thinking of going beyond the court to provide accessible and reliable dispute resolution. Thank you.
Thank you, Az. I'm now going to turn to Professor Pablo Cortés, who's also going to talk about what we can learn from dispute resolution systems in the dark world, and what could be hopefully used from those experiences in resolving civil disputes more generally. Professor Pablo Cortés does fascinating work in ADR generally. He's a professor at the University of Leicester, and this is obviously one of the latest areas which he's looking in. Thank you, Pablo.
Thank you.
Well, thank you very much for the invitation to be in this illustrious panel. I am going to talk about the dispute resolution in the dark web, in the illegal markets of the dark web. I came across this topic because I have a brilliant PhD student who was looking at blockchain dispute resolution. And even though we have a number of providers, where it's thriving only or mainly is in the illegal markets of the dark web, where people are paying using cryptocurrency. And I realized that by entering to the dark web, that these illegal markets, they have a governance structure that helps to prevent disputes. They have their own rules, terms of service, their own processes to resolve disputes, and of course, to enforce the outcome of the disputes. So I try to conceptualize this as a platform-mediated legal order, which I conceptualize or call it lex obscura. Well, let me give you sort of the civil justice puzzle of the dark web, where you have anonymous parties entering into illegal transactions, mostly about drugs, but other, weapons, illegal or counterfeit documents or services like hacking and so on. Where obviously you have encountered problems with these transactions. They are unreviewable by the courts, given their illegality. You have a high risk when you, as a buyer, enter in transactions with professional criminals. However, these darknet markets, they seem to work well. They get repeated exchange. Here we have a screenshot of below of Archetype, was only closed a few months ago, that claimed to have over 370,000 users. So why it works? Well, because it have an effective governance systems that helps to prevent disputes and to resolve disputes. But in particular, because payments don't go directly from buyer to vendor, but goes to an intermediary as cross-service. Well, let me just clarify that what is the dark web and how do you access to it? So very briefly, so you have the surface web that is what you access through Google to all these indexed websites. Then you have the deep web, where they are typically password protected, our bank details, even our social media to a large extent. And then you have a specific section that is deliberately hidden in the deep web that is referred as the dark web, and you can only access through specialized browsers that ensure the anonymity of the users. The most famous one, it's the Tor or the Onion router. Like an onion has different layers that require changing or hiding the IP address, which reveals the location of the parties. So the parties access to this website anonymously, and they can pay with digital cash, with cryptocurrency, mostly Bitcoin and Monero. And then you have this We don't know how many of these dark markets we have, but it's a few dozen of them. Most of them, they close by public enforcement authorities after a couple of years. They target the big markets, and then it's like a whack-a-mole game. Another one pops up, and well, when the users or typically the buyers encounter a dispute, because the money is held on escrow, basically as a deposit, typically by the market operator, by the administrator, they will assess the evidence provided by the parties and determine who keeps the transaction money, or whether it is divided, or whether the vendor is banned from the dark market. So we have also not just a dispute resolution process, but also a civil justice architecture that also seeks to prevent and avoid disputes. So these functions include the screening of vendors. So before they are allowed to enter into these markets to sell illegal stuff, typically, they have to pay a deposit or a bond. They are verified. They look. The administrator will check whether they have participated in other marketplaces. Crucially, they also have trust-building functions like security features to reduce the risk of having mirrors that defraud users. And interestingly, they have also reputation systems that are more granular. So they give more details. They show the previous transactions of vendors or sellers, also their past and present disputes. So obviously, in a way, it's more transparent in order to make up for that with that anonymity. And also they have embedded enforcement since they control the payment of the transaction through the escrow system, and can also ban users or suspend them if they do not comply with the rules of the marketplace. So these rules, I argue, that they do more than prevent fraud. They also allocate risk, structure expectations, and make exchange possible without court enforcement. Here you can see some examples of screenshots from a couple of marketplaces where you can see that they reveal the number of disputes won and lost by a vendor, and also you have ratings by not just by the buyers, but also sometimes by the marketplace. In terms of the dispute resolution process, the life cycle typically, it does vary from market to market, but it is generally quite similar in the sense, typically the first step is a direct negotiation between the parties. Once typically the buyer raises a ticket or a dispute, and then the moderator, the administrator of the marketplace, or a design moderator, will review the evidence presented by the parties. And in some marketplaces, they also incorporate the possibility for other users to comment on what ought to be the outcome of the dispute. There are also some general forums, like notably DRED, who have different sections for different marketplaces where parties also discuss disputes, and also parties may seek advice on how to deal with problems encountered in these marketplaces. One of the main problems that I identified in observing these marketplaces is that many of them say that the adjudicator, typically the administrator, will take into consideration the reputation of the parties. So they use basically the reputation they have acquired from previous transactions as a proxy for their credibility on the specific dispute. And once they make a decision, then since they control the escrow, they decide how to release it or to refund it to the buyer. In addition, they can also do sanctions, suspending or banning users that do not comply with the market rules. So here we see the civil justice analog of having a claim, a procedure, a decision, remedy, as well as enforcement, but some rule of law concerns in terms of using reputation as evidence. So, giving advantage to repeat players, typically buyers. Due process may be thin in the sense that you don't have, given the anonymity, you don't have guarantees that, there may be conflict of interest, for instance. And also that you cannot appeal. There is not a review available. But I argue that this platform-mediated order that prevents and resolves and enforces the outcome of disputes, it's obviously very, very effective. There has been an empirical study of one marketplace that showed that it was only around just over 200 cases, and showed that on average takes 3 days for a case to settle and 6.7 days, less than a week, for an adjudication to take place. So it's extremely fast. And here we're dealing with low value as well as high value disputes. You have consumers, but also wholesalers buying all type of stuff. In a way, it is law-like because it has rules, procedures, remedies, sanctions, and parties have institutional roles. But I have some concerns about the legitimacy of the adjudication due to the lack of transparency, the opportunity to review or appeal decisions, a lack of impartiality safeguards, and the quality of procedural standing in terms of giving the advantage to the party who has more reputation. Just to conclude, some constrained limited lessons that could be transferred to the design of lawful ODR. So we have seen the scroll system that it can reduce enforcement friction, but it cannot be a substitute, obviously, for a fair process. Granular or detailed reputation can help to build trust and triage risks, especially in these anonymous networks, but it cannot be used as a status-based proof or as a proxy for evidence. Also, having a community voice can improve participation and trust in the system or in the marketplace, but the voice should also constrain, not only legitimize private power, and both arguably occur in the dark web. And finally, the speed and informality that characterize these processes can be useful, especially for low-value digital disputes, but there ought to be also some it needs to be reasons giving the opportunity to review at least certain cases and ensure you have valid due process safeguards. So to conclude, I think the dark web dispute resolution gives an example of how civil justice can operate or migrate outside the state. And it may give some limited lessons also in the design of lawful dispute resolution processes. Although, as currently operating, they obviously do not meet the rule of law requirements. But with that, I leave it, and I thank you for your attention.
Thank you, Pablo. Terrific. Okay, so our final presentation in this session is from Walter Merrick's CBE. He is the Merricks of Merricks v. MasterCard fame, but today he's going to talk to us about his other previous roles in the form of he's been a financial services ombudsman and insurance ombudsman as well. And he's going to talk to us about the success of ombudsman schemes and also the impact those schemes have had on the civil justice system more generally. So that's over to you, Walter.
Well, thank you very much for inviting me to this interesting conference. These sessions have been particularly interesting, I think, in how to invent completely different schemes outside the legitimate world, if you like. And I'm going to talk about the private sector ombudsman schemes and how they started and how brilliantly they've taken a place in our system. If I just ask you a question, which politician, party, manifesto, government, committee, think tank, policy group, or civil servant do you think can be credited with the ombudsman out of court dispute resolution model? No, maybe there was a green paper proposal, maybe there was a consultation paper, an impact assessment. No, none of that. None of that. So where the hell did it all come from? 50 years ago, people with an unresolved dispute about goods or services they paid for were just being told, like Adrian's neighbour, to go to a solicitor, and they would just laughed at that. But 25 years later, private sector ombudsman schemes were all over the place, and we now expect them in almost every area of consumer disputes. Well, back in 1967, of course, we started with the parliamentary ombudsman, following a report by Justice, the organisation that we've heard from Stephanie. One of the novel features of the ombudsman was the recognition that it was going to be totally different from the courts. It was not going to be modelled on the common law courts, but it was going to be modelled on an inquisitorial approach. The chief characteristics were going to be impartiality and informality. That was quite a it was quite a revolutionary thing in the British system. It was not. It didn't follow what most lawyers would have expected. Now, looking outside the outside the public sector, the word ombudsman will be first deployed, and we have to in around 1980. That's where we have to look for that. And a curiously important meeting took place at which I would say two unsung heroes met to arrive at a consensus about how to set up an independent office to resolve disputes between insurance policyholders and insurance companies. They were led by the far-sighted general manager of Guardian Royal Exchange, was an insurance company, a man called Mike Harris. It was insurers, he was leading the group of insurers, that they had taken the initiative for a meeting with the National Consumer Council at the time. They had this idea that they wanted to set up something to resolve the kinds of disputes that they had coming to them from people with insurance policies of motor claims or house burglary claims weren't being settled, holiday disputes about holiday insurance, all sorts. And these cases seemed to be blocking up their general managers' desks, and they wanted to offload them onto somebody else. Now, the outcome was an agreement on the key features of the scheme that the insurers wanted to put in place, but they didn't really know quite how. And I think in the hands of less imaginative people, the outcome could have been very different. Perhaps the outcome might have been a confidential arbitration scheme for small claims, no necessary consistency, complainants paying a fee with both parties bound by the result. And I think it was Richard Thomas, who you may know his name. He became the UK's first information commissioner. He's now the vice chairman of which, the Consumers Association, an important career in consumer affairs. The scheme that he and Mike Harris designed would adopt the ombudsman name and run totally outside conventional legal models. It would operate on an inquisitorial rather than adversarial basis. The service will be paid for by the industry and be accessible free of charge to the consumer. An insurer will be bound by the decision of the ombudsman if accepted by the consumer, and consumers but the insurers would have no right of appeal, while consumers would retain all their legal rights if they were disappointed. The Ombudsman would make decisions with regard to the law, but also on the basis of what, in their opinion, was going to be fair and reasonable in all the circumstances. And the Ombudsman's powers were going to be substantial. The maximum award was initially set at £100,000. And £100,000 back in 1980 was a lot of money. But the insurers, I understand that originally in discussions at the National Consumer Council before they had this meeting, they thought, well, how much are we going to ask for? And thought, 50,000 maybe. And thought, and they thought, well, we'll go in for 100,000, see what we get. And they said 100,000. The insurers said, yeah, fine. But damn, we should have asked for more. Well, nobody really knew how this all was going to work out. Lawyers and courts were not going to feature at all, nor was the government. When I was the insurance ombudsman, one day we had an inquiry from the government department, the Board of Trade at that time for insurance, and they'd had a case that had come from an MP, and they wanted to know what the background to all this was. Well, we told them, and then they went away again. It was quite apparent that this government department, which had responsibility for insurance law, hadn't a clue about the scheme that had been running for 15 years, all dealing with insurance law disputes. Extraordinary. But anyway, well, I suppose it is typical that government doesn't, is it typical of anything? I don't know. Unlike the courts, the Ombudsman can talk freely to the outside world about industry trends that they see. They don't have to pretend to find the law when things need to be changed. They can unashamedly change position when necessary. They can consult on changes, which they do sometimes, while an ombudsman can anticipate different new changing situations while developing and applying consistent jurisprudence in their own fields. And obviously we know that the schemes were expanded very rapidly. And so now we have ombudsmen in almost every other field: energy, telecoms, estate agents and property, the removals industry, a legal ombudsman, the waterways ombudsman, even a football ombudsman, not dealing with disputes by referees or against referee decisions, but again, mainly dealing with stadium bans and season ticket renewals. And all these disputes that are resolved by ombudsmen are essentially justiciable contract or tort claims. And as such, I would say their resolution forms part of what we should call, and what we do call, the administration of justice. And the ombudsman role is thus a semi-judicial one. Despite pleas to the government, there's no single department of state responsible for the oversight and protection of ombudsman schemes, and that does leave them somewhat vulnerable, I have to say. The sacking last year of financial ombudsman Abby Thomas under Treasury pressure over her stance on motor finance complaints was a dreadful example of what can happen. Well, I just simply say that the ombudsman schemes are to be celebrated, and we should be really pleased that they exist. They have completely denuded the civil courts of any cases in these areas. We have cost-free, risk-free access for consumers to deal with the vast majority of consumer type complaints. And we have developed them in this country and exported the model to most of the Commonwealth countries as well. So I say we should look back with pride at how we have developed an out-of-court, such a successful scheme that's been modelled elsewhere, and be grateful to those two individuals, Mike Harris and Richard Thomas, who I say unsung heroes. Thank you.
Thank you all. Fantastic range of presentations, both old and new technologies. I just have a first question both to Az, but also something that Pablo was saying about what we can learn from it. Because generally speaking, in instances where civil courts is a form of state coercion, and normally where the state coerces others, that requires a degree of public accountability and transparency and reasons. And so given that that basic framework, what is the scope to take the much faster, much quicker, much perhaps more effective dispute resolution processes in the offline world, in the illicit world, into the public realm? Where would it work? What lessons can we take from it? Where could it be incorporated?
Well, we are wedded to this idea of reasoned judgments. But as Lord Briggs has pointed out in a recent lecture, vast quantities of disputes are decided on market platforms like eBay and Amazon without any kind of reasons, and people are satisfied. People are getting more and more used to AI systems which provide very few reasons. So there is already a change happening in that regard, and people may think, well, might start thinking, well, a quick, fair resolution, which works for most people most of the time, is better than the expensive and unaffordable one.
Hello?
Of course, I agree. I mean, I think specifically from the dark web, more lessons could be taken to scenarios that are where justice is decentralized, but perhaps with cross-border disputes, where anonymity it is necessary, maybe with whistleblowers. When we want to invite the community to express a view, like actually Cleros has entered into a pilot in the state of Mendoza in Argentina to use an online jury to determine the outcome of certain civil cases, and their views are not binding on the judge, but obviously they seek to democratize and to legitimize a system. So there are, I think, some lessons that could be applicable, limited lessons could be applicable in the public sphere, but we also have to be aware. I mean, I was something that always shocked me when looking at how it works in the dark web is that the more effective the dispute resolution system is, the more undermines the rule of law, because incentivizes for the illegal transactions. But still, it shows that the system is effective, very effective in practice.
The lesson clearly is that we should decriminalize drugs. That would put that.
Okay, well, questions.
I think the key thing here in this debate is to separate two different technologies, blockchain on the one hand and artificial intelligence on the other. The impression from the talks that were given is very much one based on blockchain-based technology.
and portraying what happens mostly as something that's quite negative, happening in the dark web, I guess. So blockchain-based technology has big advantages, and the biggest advantage is enforcement security and certainty. And that's good. That's something that's helpful for dispute. The great disadvantage is in coming to a reasoned decision. And Adrian Zuckerman pointed out the decision-making mechanism with respect to clouds. Now, it's not as bad as you portrayed it, because in the absence of other factors, your best guess as a voter or a juror is you have reason to believe that the others, probably also the majority, are trying to orient themselves at what the law is, because that's probably a majority decision is going to be. But it's easy to construct models where, for one reason or another, the equilibrium is pretty different. If you have reason to believe that the majority follows frenzy, which is widespread, then you can get an outcome which is totally different from the law. And this is where artificial intelligence can be. You need some kind of technological support to help the decision maker, whoever it is, to come to a reasoned decision which is based on principles that are taken from what the law is. And the latest artificial intelligence models do that. Not only do they predict what the outcome is, the right outcome, they also give reasons. So it's not the case that they don't get the reasons at all. So in sum, I think the key really is to bring together the advantages of blockchain-based technology and the advantages of certain AI models. And that's where also state-run systems can learn from and integrate elements of these combined two technologies into their system.
It's very, very fascinating. I entirely agree. Never occurred to me before, because I thought that the advantage of blockchain is maintaining human judgment, because surely a lot of places won't talk about the efficiency of AI. It just can't basically. So I thought the advantage is to remove AI and keep the human judgment predominant. But you are quite right. We can use artificial intelligence as quality control. Excellent. Really wonderful idea. Thank you.
Anyone else?
I was just going to add, well, this is all very fascinating, new to me, I have to say, but I guess these systems are relatively new. Haven't been going for all that long. As they continue, then they will make their own jurisprudence about how it applies to certain qualities of drugs or whatever. So they will actually begin to develop precedents that they will want to apply. Now they may be helping them in applying, but there's no doubt that all these out-of-court resolution systems, if they deal with enough cases, will want to be consistent in the decision-making model they're using.
More question.
I have a rule of law worry about the proposals you guys are making, and it's a slightly different one. It's about what you mentioned, Professor Zuckerman, about eBay and Amazon and their dispute resolution mechanism. So the worry is that under the rule of law, we hopefully should be guided by rules and principles which are openly accessible and which we can see and which we can read and understand. And one of the big benefits of having judges making reasoned decisions isn't specific to the parties. It's because we can then look at what the judges said and we can understand why they came to the decision they came to. And we know that they're later going to be bound by those same reasons. And that's a public good, which is probably going to be undervalued by the parties, because the parties overwhelmingly will just want someone very quickly and very fairly to tell them what they should do. And so my worry is that the more we push parties towards alternative dispute resolution mechanisms, the more we lose that public good of the rule of law being guided by open, accessible principles. Which is why we should be worried about massive corporations like eBay and Amazon solving huge numbers of disputes entirely within their control. That seems like not something to welcome, something to be very worried about, to my ears anyways. So I was wondering what you guys thought about that.
Okay, thank you, Moed, for channeling Owen Fiss.
I entirely agree with you. Absolutely, and I wrote about it. If you leave it to AI, the whole business of open justice, visible justice, justice mutual involvement will disappear because the justice would occur in the interstices of the computer in no particular geographical place. And certainly it's a threat to the rule of law. But it's also a threat to the court's failure to provide adequate dispute resolution is also a threat.
And I totally agree as well, but I think there is the opportunity when you're using technology to record also the decisions and even ombudsman bodies to some degree are generating precedents, especially when they have a high volume of similar cases and they develop guidelines. Obviously the key is to obtain that critical mass and in order to be able to provide these precedents and also to be transparent and also to allow to some degree of an appeal or a review system in order to develop these guiding principles and precedents, which currently is not available specifically in that way, but we can see that, for instance, in ombudsman schemes where you have that second tier of more senior adjudicators, ombudsmen, that they do review and do provide some consistency in the application of the law.
I've got a question for Walter, which is that I mean, some ombudsman schemes are lauded as being extremely successful. But one of the complaints is that sometimes the quality of ombudsman services vary across different ombudsmen. And I mean, just in your experience, how would you explain that? What is the key to success? Why are some schemes appear to be more successful than others?
Well, it depends how you assess success. Yeah. You know what is, of course, the banks have been very upset with the financial ombudsman and tapped the government on the shoulder and said, "Can you do something about this financial ombudsman?" And that's what they got. Why they got rid of Abby Thomas, and they gained. There's more in the King's speech about cutting back on the financial ombudsman's powers. So it's not just. But coming back to your question, well, I think the bigger schemes have been able to develop good quality systems for training of staff, that sort of, which small schemes can be a bit more rickety. They may be not as well resourced, or their management has not managed their IT investments properly or as well as they might do. So it's probably not the sort of factor that you'd expect in smaller organizations that may be less consistent, less able to invest in consistent management systems, if you like.
Right, thank you. Is there a final question before we wrap up? We've got a 10-minute break before one further question, and then we'll.
These dispute resolution bodies, where, for instance, these dark-left dispute resolution bodies don't have the same legitimate coercive powers of courts. They don't have the ability to, for instance, chase judgment debt or wind up or bankrupt people to satisfy that debt. On the other hand, I think in the ecosystem of the dark web, there's no shortage of illegitimate coercive bodies and powers. And in that sort of system, I'm just perhaps a bit curious as to why these institutions have that level of institutional legitimacy, as opposed to, for instance, coercive, violent mechanisms where the parties towards these drug deals or arms deals can resolve their dispute in a violent manner.
You are making a big mistake in thinking that criminals want to rely on violence to enforce their rights. It's very inefficient. It exposes them to all sorts of risks. They want a peaceful resolution. It's much better for business than sending thugs. So that's what the dark web provides. A very
I speak from experience.
I wish.
On top of that, obviously, there's the issue of anonymity. So, you have that protection, given that, you don't know what the location of the parties are. They, are safe from physical threat. One thing, the other thing also, the enforcement is obviously limited to the payment in the transaction, typically. And there has been cases where when they shut down the marketplace, there is no resolution. If the police shuts the marketplace, those transactions that are ongoing, they're left open. So there are these limitations.
But I say that on the whole, they expect to continue to do business with each other. But just this set of transactions is disputed. But maybe they want to continue. That's always a feature, I think, of civil justice resolution, that many of the parties actually want to continue to do business whilst having this particular dispute resolved.
All right. Thank you. That was a wonderful set of presentations, eye-opening for everyone, I suspect. We're going to have a short break, and then we're going to have Lord Briggs' keynote address. So we'll be back at 5:30. Thank you.
Well, thank you very much, and for inviting me to this fascinating conference. I've enjoyed hearing a great deal about the past and the present, and now it's time to go back to the future. Civil justice continues to lie at the heart of the rule of law. The rules and principles governing civil procedure remain vitally important. As Lord Justice Burse recognised in his foreword to the most recent edition of Zuckerman on civil procedure, the exercise of identifying the principles and making the rules is a task that has been greatly complicated by the advent of digital technology as the primary medium of communication in civil litigation. I would add, and this is my principal theme this evening, that those complexities have only been further intensified, perhaps eventually by an order of magnitude, in very recent times by the rapidly developing influence of AI. In this short address, I'm going to address three central themes. One, that the lessons to be derived from the adaptation of civil procedure to deal with digitization reveal a cautionary tale. When digitization was on the rise, the development of procedures to cope with the change to digital courts occurred very slowly and in a piecemeal way. We're now on the precipice of another technological revolution in the form of AI. The message I want to emphasize is that we ought not to be quite so slow in devising appropriate rules to regulate and accommodate the use of AI in civil practice this time round. Secondly, I will consider the AI revolution itself to outline the potential challenge that the principles and rules governing civil practice will need to meet. A main feature of that challenge will be to accommodate a tsunami of small to medium-sized civil litigation brought by litigants in person, acting without lawyers. Thirdly, I'm going to explain what I call the democratic question, concerning the use of AI by the courts and by judges in particular. This is not about whether the functions and capabilities of AI are useful in assisting lawyers and judges in performing their work. The direction of travel already suggests that they clearly are. Rather, the democratic question is whether AI can or should actually replace human lawyers and judges in the resolution of some, or even all, types of civil litigation. It's a democratic question because it's ultimately not a question appropriate for judges or lawyers to decide. It's a matter for the people and for taxpayers in particular. The key takeaway is that we ought to begin to think seriously about developing procedural rules and regulation to accommodate AI in advance, rather than responding piecemeal to technological developments as and when they occur, as we did with digitization. And we ought now, before it's too late, to identify just what contribution to the rule of law is actually made by the human elements in the process, and how to preserve that from erosion. So looking first at digitization. When I was called to the bar in 1978, there were no skeleton arguments, no pre-reading, no word processors, just golf ball typewriters, no internet, no mobiles. There were also very few women, at least in the Chancery Division, though I was lucky enough to marry one of them. Still less were there very many women on the bench. On the other hand, there was much greater transparency, plenty of legal aid, limitless pupilages but scarce tenancies in tiny little sets of chambers. All hearings were face-to-face. Everything was read out in court, so that a member of the public sitting in the back row could understand what was going on almost as well as the judge. How that has changed. This has all changed, but quite slowly. The CPR arrived in 1997. Since then, civil procedure rules in England and Wales have been made by the Civil Procedure Rule Committee, established by Section 2 of the Civil Procedure Act of 1997. Whether the CPR really revolutionized or simplified civil procedure has been much debated, but it's not a subject for this evening. Digitization occurred in fits and starts from around 2010. It's still not complete, both in the County Court and even on the King's Counsel's desks in the Supreme Court. They generally still use paper. and indeed so do some of my colleagues, at least in part. In my civil court structure review in 2016, I identified what I thought was the principal weakness of the civil justice system in England and Wales as being very poor access to justice for the pursuit of small to moderate civil claims because of the disproportionate cost of instructing lawyers and the costs risk of having to pay your opponent's legal costs if you lost. I advised that it might be remediable by the introduction of a digital online court with built-in automated triage for litigants without lawyers, to help them formulate simple claims sufficient to enable them to translate their grievances into a format which the court and their opponents could understand, respond to, and adjudicate upon. You might say a rudimentary form of AI. However, the success of the online court, I thought, would critically depend upon the implementation of up-to-date IT systems and digital assistance for litigants challenged by the use of computers. In addition, I recommended that embracing digital processes would address the second fundamental weakness of the system, that is, the heavy reliance on paper-based processes, which I called the tyranny of paper. I also recommended that an online rules committee be set up as a matter of urgency to do the necessary blue sky thinking about digitization in advance of the implementation of the new technology. And that was a recommendation I made in 2016. My recommendations were almost all accepted by both sides of the justice partnership, that is, by the judiciary and the Ministry of Justice. The potential advantages of digitization for litigants and for the judiciary were widely acknowledged. When setting out their joint vision for transforming the justice system in September 2016, just after I delivered my report, the Lord Chancellor, the Lord Chief Justice, and the Senior President of Tribunals stated in a joint statement, I'm quoting, "Looking ahead, we need to make sure that our justice system continues to lead the world. To do this, our system needs radical change, to have modern IT and processes, and to be located in buildings which are fit for purpose. The reforms outlined here will achieve that by combining our respected traditions with the enabling power of technology." However, despite securing the necessary investment to effect the change to digitization, the procedural groundwork was not carried out in advance. It took until 2022, a full 6 years after my report, before the necessary primary legislation for an online rules committee was even passed. This meant that procedural rules to accommodate digitization were developed in a piecemeal and ad hoc manner under the overall authority of the Civil Procedure Rules Committee. Often, the new rules were introduced as pilot scheme practice directions, temporary procedural rules designed to accommodate new electronic or digital methods, which were adopted contemporaneously with the relevant development. For instance, in 2015, a new electronic system called CE File was introduced for specific courts in the Rolls Building. Its purpose was to enable parties to issue proceedings and file documents with the court online on a 24/7 basis. Of course, procedural rules were required to govern the use of the new system, which was introduced as a pilot practice direction under CPR Part 51, namely Practice Direction 51.0, entitled the Electronic Working Pilot Scheme. Lord Justice Burse has recently pointed out that the implementation of this new system meant that PD 51.0 was, quotes his words, drafted in a hurry, quotes off. Nevertheless, as the CE file system was then extended to other courts, this, quotes, pilot, quotes off, practice direction was also extended and remained substantively unamended until its drafting errors were finally addressed in 2025, when PD 51.0 was finally retired. In the meantime, PD 51.0 had stayed in force for almost 10 years. In the years that followed, several other pilot practice directions were introduced to accommodate digital innovations in a similar way. They're all under CPR Rule 51. So in August 2017, the first pilot practice direction for the online civil money claims procedure was introduced, PD 51R. This PD established a pilot scheme to test an online claims process
for small claims in the county court designed to be used by litigants in person. In May 2021, PD 51ZB introduced a pilot scheme to test an online claims process for county court damages claims where the parties are represented by a legal representative. That's the damages claims pilot scheme. This involved managing claims using an online portal, calling the damages claims portal. And then in January 2026, PD 51ZH, you can see how many there were, introduced the access to public domain documents pilot to help provide easier access to documents deployed by parties in court proceedings. Now, there certainly are some advantages to using practice directions to govern pilot schemes instead of rules, particularly where the underlying technology is ever developing and the system is prone to change. Speaking in June 2019, at a time when the digitization of dispute resolution was focused on the online civil money claims project, the late Sir Terence Efferton, then Master of the Rolls, recognized that an important advantage of CPR Rule 51.2 is that it allows practice directions to override the CPR as part of a pilot scheme, and PDs can be made and amended relatively simply, in contrast to rule changes which require a statutory instrument to be laid before Parliament. This is particularly useful where the drafting of the rules is expected to go hand in hand with the construction of the underlying computer system, because it allows procedural rules to be adapted more quickly and easily in responses to changes in how the system turns out to operate in practice. However, as the experience with PD 51.0 reveals, it's clearly not desirable for a mere practice direction to remain in force as a practice direction for such a long time, certainly not for 10 years, apparently on the basis of convenience, especially where it was thought to contain some unsatisfactory provisions. Clear and predictable rules are to be preferred wherever possible. A more fundamental question is whether this hand-to-mouth way of making procedure rules is itself fit for purpose. In asking this question, I mean to imply no criticism at all upon the skilled and hard-working teams, led by Lord Justice Burse, which actually produced the pilot practice directions. They did a fantastic job under grave pressures of time, not to mention the pandemic, and with no overarching guidance from a suitably constituted rule-making body. It was not until the Judicial Review and Courts Act 2022 and a formal launch in 2023 that the Online Procedure Rules Committee was introduced. It took around another 2 years for a statutory instrument to be enacted confirming and delimiting the scope of the Online Procedure Rules Committee's power to make rules for specific kinds of online proceedings. And now in May 2026, although the OPRC has now produced some draft online procedure rules, which appear to have attracted broad support from respondents to a recent consultation, the OPRC is still yet to finally issue any rules. It's now a full 10 years after I published my report, suggesting that it be done urgently. It's difficult to countenance employing practice directions to govern technological developments in civil process on an indefinite and ever-increasing basis. But it is also necessary for the process of rulemaking to be swift enough to keep pace with these developments. My concern is not that the rate of production of the successive practice directions was too slow, but rather that it proceeded in a vacuum of governing objectives and principles, and was in effect just driven along by the detail of the technological developments as they came off the digital production line. There were, of course, committees and working groups of civil servants and judges supervising the technological advantages themselves, on a number of which I served. And they did look at the underlying objectives, but they were entirely private, behind closed doors, whereas the rulemaking process is and should be essentially public. But I wish to highlight a slightly anterior point, and that is that when one can see a groundbreaking technological development looming up on the horizon, and it is reasonable to predict the sorts of innovations which that development will or might bring about, then it's a good idea to begin thinking critically about what should be the objectives and principles behind the rules which might need to be developed before those developments start to become absorbed into civil practice. Now, that doesn't mean that we must have all the answers up front. We can't hope to anticipate the detail of the rules that were required to accommodate technological systems which are yet to materialize. But it is prudent to begin thinking prospectively about how we plan to go about defining objectives and principles to inform and inspire the rules needed to govern technological advantages in civil procedure that we can foresee, rather than waiting until those developments take hold and compel rules to be formulated rapidly, reactively, and without the guidance of clear-cut objectives and purposes, worked out on a transparent environment which is open to public scrutiny. It may have been no one's fault, but unfortunately that is not what happened when digitization was round the corner, and we should be careful not to make the same misstep again now that we are on the verge of another technological revolution which is likely to impact civil justice even more than did digitization. That revolution is, of course, AI. Its influence on the justice system was long forecast by the lone voice crying in the wilderness of Professor Richard Susskind. But did we really believe it? When I completed my report in 2016, AI was still mainly over the horizon, or perhaps just a little cloud on the horizon, no larger than a man's hand. At that time, the general feeling was that robots would never replace judges, nor indeed advocates. Now, AI has rapidly gained prominence within the legal profession, emerging in about 2023 to 2024 and becoming increasingly normalized from about 2025. Now, virtually every law firm and perhaps most barristers' chambers are embracing some form of bespoke legal AI tool, and the courts are just about beginning to follow suit. AI is also developing at breakneck speed, and this is key, it's available, at least in its basic forms, for free. Indeed, some form of AI is now embedded in most apps, e.g. Google, Microsoft 365, Lexis, Westlaw, and so on. AI is certainly going to revolutionize access to justice for litigants in person. However, the same attributes which make it such a valuable tool for enhancing access to justice also give rise to two difficult and interlinked questions, one practical and the other democratic. Let me first look at the practical question. As I mentioned, there are now a group of competing open AI LLM platforms available to the public, either for free or at a very modest subscription. When in the hands of a non-legally qualified complainant with reasonable computer skills, those platforms can even now be used to generate possible particulars of claim out of the user's stream of consciousness description of their grievance. It may not be as good as a draft prepared by a qualified lawyer, but it will certainly be sufficient to get the complainant through the court door as a litigant in person. Of course, it won't yet be quite as good as a professionally prepared claim, and it may initially contain fakes, mistakes, and hallucinations, although we can expect that the development of AI technology will eventually iron out most of those defects. But critically, it involves no input from a lawyer, and apart from a modest subscription and court issue fee, it's free. And would-be litigants in person can also get legal advice from AI platforms, also for free. I know, I've done some experimenting. The other day I put exactly the same legal question to Google AI and to ChatGPT. I emphasize on my private, not my work laptop. And I got two completely opposed answers. But lawyers don't always do much better. Now, it's obvious that this development could and probably will have seismic effects on access to justice. I've described them on other occasions as likely to lead to a tsunami of small to moderate value civil claims, once litigants are enabled by OpenAI to formulate them and get basic legal advice about them without the assistance of lawyers. And given the huge sums being invested in the development of this type of AI, its performance is only going to improve. In short, the robots are getting cleverer quicker than the humans. So in principle, AI promises to be a boon for access to justice. However, the practical problem is that the big increase in the number of claims will only produce better access to justice if the courts, staff, and judges have the capacity to manage and adjudicate on them within a reasonable time, rather than, as for criminal cases in the Crown Court, and indeed the time taken to get to trial in the County Court, just add them to an ever-increasing backlog. And there the equation starts to get rather complicated. At present, the civil courts use humans both for case management and adjudication, with some help from digitization, but almost none from AI, although that may be about to change. The problem is that an AI platform may take seconds to advise upon and a few more seconds to draft a civil claim, but court managers and judges will typically take more time by orders of magnitude just to read and respond to the claim, let alone to adjudicate upon it. 10 years ago, when the civil courts made a healthy annual operating surplus of approximately £100 million a year, it might have been thought that more court staff and judges to handle an ever-increased profitable workload was an economically viable option, which taxpayers would rather like. But the surpluses were all swept away by the pandemic and have still not returned. So civil justice improvements within the courts are going to have to be funded by government at the expense of the taxpayer. At present, it seems unlikely that the taxpayer will wish to fund a big increase in the staff and judges of the civil courts, not least because the awful and increasing backlog in the criminal courts is probably, most people would say rightly, going to command a higher priority for scarce Ministry of Justice funds. So the practical question is, how can the civil courts prepare themselves to cope with the impending tsunami of civil litigation? In my view, it's inevitable that AI is going to have to come to the rescue of court staff and judges in increasing their productivity. In fact, this has already started to happen, and the Ministry of Justice, the Court Service, and even some judges make no bones about that. While state-funded institutions are unlikely to invest anywhere like as much in AI as do big law firms and chambers, the robotization of the court's response to incoming AI-prepared claims is just going to have to proceed apace if the civil courts are not going to sink under the burden of the tsunami. Naturally, however, this begs the question, what precisely are the courts going to use AI for? In my view, that's ultimately, as I've said, a democratic question. It isn't really for judges to decide whether they or robots should adjudicate upon people's disputes. So I come to the second question, and that is the democratic question. It's well known that one of AI's great strengths is its capacity for streamlining and therefore speeding up and making cheaper processes that would otherwise have to be performed manually or mentally by a slow and expensive human brain. Senior members of the judiciary have recognized that AI can be harnessed as a labor-saving device to assist with such tasks as summarizing lengthy legal documents or court files, conducting legal research, particularly at the initial stages, checking grammar and spelling in draft judgments, streamlining case management. So long as AI, or robotization, is confined to performing these kinds of tasks at the edges of the process for the determination of civil claims, one might fairly ask, what's the problem? You might say, as Sir Geoffrey Voss, Master of the Rolls, has recently put it, that, quotes, AI is just a tool like so many other tech tools we use every day, quotes off. I would agree, but only up to a point. The trouble is that while this sort of assistance will speed up what is still essentially a human-run process, it isn't going to increase productivity by anything approaching the necessary amount to cope with a tsunami. And we can't and shouldn't try to control it by increasing court fees to stem the tide, as we know from the Unison case. So the big question is, can, or more importantly should, AI replace the human element which currently lies at the heart of judging? And if so, for what kinds of case? I've described this as a democratic question because it ultimately boils down to what the public want or are prepared to accept and pay for. Should or should not AI be used by the courts instead of judges? Who or what does the public want as the arbiter of their disputes? And how much will they be prepared to pay out of their taxes for the expensive human elements in the process if robots can do it on a limitless scale, more quickly, more cheaply, and perhaps eventually almost as well? My guess, which is informed from discussion during my review 10 years ago, but unshaken since then, is that the average taxpayer may be happy for a robot to decide small disputes, for example, about the sale of a second-hand kettle on eBay. But if the dispute is going to put at risk their liberty, their home, their access to their children, or bring about their financial ruin or bankruptcy, then they would, at the moment, prefer such matters to be decided by a human rather than by a robot. Judges dispense justice, but also equity and mercy. And it may be said at a more theoretical level, but humans are at least better at dispensing equity and mercy than robots, and at the moment, although this may change, better at reasoning. My current view is that there is probably a hard-to-define threshold or spectrum between those cases which the public may be happy to have resolved by a robot, usually on the grounds of speed and proportionality, and those for which they would still prefer a human, i.e. a judge. And that line may well shift back and forth over time. A critical question is how far AI is to be allowed into the currently sacrosanct space of judicial decision-making and judgment drafting. The recent arrival on the scene of agentic AI makes it by no means implausible that an AI platform could soon be tasked with the whole process of coming to a decision on a case and then doing at least the first draft of a judgment, setting out the reasons. If the only role of the judge was to approve the AI's plan of action and then to review the draft judgment, would the current public expectation that the litigant is getting a human judge to decide the case really be fulfilled? And if the typical judicial role in the future became that of a reviewer rather than an initiator, how good would that be in developing or even maintaining their judicial skills? So the integration of AI into legal practice is likely to generate difficult, practical, and democratic questions, and they'll have to be answered about the extent to which the courts use AI to meet the challenge. And there will also need to be complete transparency about just how far AI is assisting, or in certain areas replacing, the work of human judges, so that the truth about what is going on behind the scenes doesn't get out of step with public expectations. And if human judges want, like me, to preserve their usefulness in upholding the rule of law, then we're going to have to think hard about what human qualities may never be going to be supplanted by robots. The fact that whether they are or are not to be supplanted is a democratic question doesn't, I think, mean that judges should maintain a stoic silence about the possibility of their impending doom. So how should the courts prepare? What does it mean for our approach to civil procedure? I suggest three things. First, to begin the process of designing procedural rules to govern the AI-based innovations that will become absorbed into the civil justice system, we should start thinking now about the probable applications of AI. This means considering what litigants and the courts could be enabled to use AI for, at least in the foreseeable future, and how the sorts of risks that are known to be associated with AI, at least at present, might best be addressed. For example, if AI is going to be used regularly by litigants in person, or indeed by counsel, to draft applications or written submissions, should there be procedural rules mandating the disclosure of their use of AI? Should the current expectation that counsel checks every bit of AI input into, for example, their legal research and written submissions, be transformed into a firm procedure rule? Similarly, if judges are to begin routinely using AI to assist in the drafting of draft judgments, must this also be disclosed? Should such use be restricted to checking a draft that a judge has prepared, or can the judge ask the AI tool to prepare a first draft that he or she will then just amend or approve? This takes us back to the democratic question. Secondly, in considering how the courts might prepare for the tsunami of AI-generated cases, it's instructive to look at the approaches of other jurisdictions which were early adopters of AI. For example, it is well known that Brazil has struggled for some years with a staggering backlog of cases, something like 80 million. According to one study published in December 2025, Brazilian judges render an average of 9 decisions per working day. So it's no surprise that AI has gained traction there as an attractive tool for speeding up court processes. But Brazil has also regulated judges' uses of AI in certain ways. Firstly, it adopts a dual-track approach, in which the use of court-provided AI tools is strongly preferred. Judges can then use subscription LLMs, but if they choose to do so, the law dictates that they are personally and entirely responsible for the decisions made and for the information they contain. In contrast, there's no equivalent liability arising in connection with the use of approved institutional AI tools. Next, judges must undertake mandatory AI training if they wish to use AI products in their work, whether the institutional tools which are supplied or private subscription tools which they want to use themselves. Data protection laws generally prohibit using private LLMs to process confidential documents or data. Under the Brazilian regime, judges may choose whether or not to disclose their use of AI in written decisions, but the court's internal system must automatically register such use. And finally, this is all enshrined in regulations enacted and published by an administrative quasi-judicial body. In other words, these rules and regulations are all in the public domain, which is how we've been able to get access to them. Of course, I don't intend to say anything here about whether the rules in force in Brazil are effective or sufficient to govern the use of generative AI by judges there or, for that matter, here. For present purposes, however, what the Brazil framework does highlight are the kinds of policy choices and problems that the rules will be required to address if the civil courts and judges are to use AI platforms to meet the challenge posed by the tsunami in a transparent way which will command public approval. These are things we really ought to begin thinking about in earnest now. Thirdly, given how rapidly AI is advancing, it will also be necessary to think about whether our current system for producing rules of civil procedure is sufficiently agile to keep up with the technological advancements in civil process that AI is likely to produce. It struggled to keep up with digitization, but AI is now developing at a much faster rate than ever did digitization. There's another way in which confining one's gaze to procedure rules may miss the point in establishing democratic control over the use of AI in maintaining the rule of law. At present, we enjoy a justice system in which those who intermediate by presenting and deciding cases, that is, human lawyers and judges, are all practicing a vocation, i.e. to perform a public service. And they're subject to professional ethical standards and regulation. In addition, the judges take an oath of loyalty to deliver justice, equity, and mercy without fear or favor, affection, or ill will. But the platforms which deliver AI-generated legal services are all owned by a very small number of large, mainly USA-based corporations, which are neither regulated by nor bound by any kind of loyalty to the UK. Nor, however friendly the robot voices may sound, and I know I've listened to some of them, are they in any sense performing a vocation. They're just there to make money and maybe one day to rule the world. It may well be that procedure rules are not even the main way of keeping AI in the civil legal arena within democratically acceptable bounds. Other forms of regulatory discipline may need to be contrived, starting from ground zero, rather than building up from the familiar confines of the CPR. So in conclusion, AI, like digitization before it, has the potential greatly to enhance access to justice. Never will it have been so straightforward and cost-effective for litigants seeking to bring small to medium civil claims to get through the court door quickly and at negligible cost, and without needing any recourse to lawyers. The problem is that the door may well burst off the hinges if the civil courts become inundated by a tsunami of claims without adequate mechanisms in place to cope with them. I suggested it seems inevitable that the courts themselves will have to harness AI platforms if they're to avoid sinking under the burden of the tsunami. That gives rise to both practical and democratic questions. How can courts and judges use AI effectively to manage their workload? What AI tools exist or could be adopted at acceptable cost? Would those tools be useful? Should judges use AI tools in their work? And if so, for what purposes? And how do those suggested uses cohere or conflict with public perceptions and expectations about the role of judges? When digitization occurred, we were slow to adopt the necessary procedures to adapt to the change. I hope that this time round we begin much earlier to do the vital blue sky thinking. What are the objectives which the greater use of AI should serve? What are the currently valued contributions which human judges and court staff make to the justice process? What red lines need to be put in place to ensure that AI doesn't trespass into or undermine that human contribution? If we don't do that thinking up front, then we may well open a path to the elimination of judges from the process of maintaining the rule of law, or at least from much larger parts of it than the public would wish. And if we replace the judge with a robot, then why should there need to be a human lawyer intermediating at all between the robot drafter of the claim or defense and the robot adjudicator of it? Who knows? If the judges and the lawyers become expendable as being too slow and too expensive, the only human survivors in the brave new legal world might be academics. But who would they have to talk to about the law other than themselves? Make no mistake, I firmly believe that both human judges and human lawyers, and incidentally academics, have a central, vital, and mainly irreplaceable role in maintaining the rule of law and providing access to justice, which isn't going to be outperformed or even equaled by AI anytime soon, if ever. But I do think that we should now recognize the increasingly urgent need to identify just what those irreplaceable human qualities are, to polish them up so they shine brightly in what some may regard as the gathering gloom, and to sell them to the public, who we rely upon to pay for them. And in that endeavor, academic lawyers are going to be central to the task. Thank you.
Thank you, Lord Briggs, for that sobering account of how the challenge that we're going to face in dealing with the impending tsunami of AI-generated civil litigation. Before I open to questions, I do want to invite Professor Zuckerman to come up and just say a few words in relation to Lord Briggs' contribution to civil justice over the years.
Michael ended his wonderful, insightful, and elegant speech with the role that academic lawyers have to fulfill in relation to AI. Well, they are not going to fulfill this role in relation to AI because there are very few of them. England is the only country in the entire world, that is a very civilized world, where civil procedure is not taught in universities. So there have been no academic lawyers in this country until very recently, and we are really very few. But there were people who did contribute to civil justice. And we were very lucky to have 4 such people. The first, see, the civil litigation is governed by rules. The rules are very highly technical on the whole. And judges see only the case before them. They don't see the system as a whole, and they apply the rules in a piecemeal and necessarily limited, with a limited view to the social and systemic consequences. But there have been exceptions. So in the last part of the 20th century, there was Sir Jack Jacob, who pioneered the attention to rule, the need for reform, the need for comprehensive and logical systems and their effect on the society as a whole. And he laid the ground to the Wolf reforms. The Wolf reforms, we were then very lucky to have Sir Henry Brooke, Lord Justice Brooke, who ushered in the civil procedure rules and explained to the judiciary in particular, as well as the profession as a whole, their significance, their culture and their direction. And they had a huge influence, particularly on the appeal system. He was then succeeded as a visionary by Lord Dyson, who kept the system together and safeguarded it against this judicial centrifugal of fragmentation. And now we have a very fit successor to these industrial pacemakers in Michael Briggs. He is not influential like his predecessors he's not influencing the system by the authority of his office. He has none. He's just one of 10 or 12 justices of the Supreme Court, but he's influencing the direction of civil justice, like his predecessors, through his vision, through his commitment to the system, and the desire to leave the world a better place, at any rate, the world that we as lawyers know. And his speech just now illustrates that he is able to rise to the challenge of this enormous change that is taking place and is about to take place. And what makes me particularly happy, well, let me say one thing. Look, I have my reservations about him. He's not perfect. I've just learned that he has shown very poor judgment in supporting Arsenal rather than Manchester City. This is, but nonetheless, we have, in having people like him, we have some hope that things might not be as bad. The developments are quite threatening to the legal profession, as they are to jobs for everybody, for all graduates. They might not be as bad as might be expected, and he's not finished yet. So I'm delighted that I to live at a time when there have been people like him around, and to benefit from the exchanges that I've had with people like him, because really the civil justice system here has not been made or influenced by academics, but by people like Michael. Thank you, Michael.
I'm going to open up to questions. Sir.
Stephen, as someone who's been following, it has been really, really radical. One of the things that came to mind while I was listening to you, so we currently utilize AI tools designed to respond to and perhaps even to some extent validate the user input. So essentially, if a user puts in a stream of consciousness, emotional rant about their litigation, AI might validate it and essentially mimic the sort of client-lawyer relationship that's created by the pro-litigation sort of fee-incentive misalignment that we currently have between the lawyer and the client, and create this pro-litigation by pushing clients into, as we said, courts. could this be used as an opportunity, and could legal AI be designed deliberately as a mediation or settlement first counselor? Should it be one that sort of presents litigation as a last resort after modeling costs, duration, enforcement risk, reputational consequences, etc.? Ergo, sort of assisting in perhaps limiting the number of people that go into court. Is that a possible solution? And should there be such interference when it comes to designing structurally legal AI tools that we currently have in the market?
I hope so. The Master of Rolls, as you know, has been in the forefront of trying to develop a system under which one's entry into the court system, because one has a dispute, absolutely guides one into all those directions, the which you might call ADR, alternative dispute resolution directions first, leaving the court as a last resort. Whether the current form of LLM type OpenAI tool can do that is, to my mind, rather doubtful, because it has its own training, it has its own approach to how it's going to advise you, and you can put in a standard prompt, if you like, that encourages it to send you in all those directions by asking what are the alternatives to going to court, but that will only respond if you do so properly. Now, you could develop a legal AI tool for that purpose, but they're expensive. They're not a substitute to your ordinary member of the public for going to court with a small or moderate dispute. The substitute for them is either free ChatGPT or the type one up the stand for which you pay, say, £30 a month. So I think while I share your aspiration, I'm not sure I can see a clear path to putting it into effect. I will also add, of course, that it would be nice if it sent you off to the ombudsman, because I agree with everything that Walter Merrick said earlier about what a marvellous service that alternative to going to court performs.
Sam, and then Stefan.
Well, Briggs, you know that the future role of AI in the justice system is a democratic question to be decided by the public debate and Parliament. Do you have hope as to the quality of that public debate and circumstances where the two most informed parties are lawyers who have a significant amount to lose and AI providers who have a significant amount to gain from the future form that the justice system takes?
Well, the bit of it which I'm looking at is the role of AI actually within the court system. And ultimately that is paid for by the taxpayer, because it doesn't make a surplus at the moment. It used to, but it doesn't. There's no sign it's going to again anytime soon. So that when I say it's a democratic question, I mean, it'll ultimately be governed by what government perceives that the public are prepared to pay for, and therefore, if push comes to the shove, vote for. And I quite agree that there's some very large, rich, well-heeled organisations pouring fantastic sums into AI, which may want to play their own part in influencing public views. Of course there are. And I'm only saying that lawyers should be getting out there doing exactly the same if they want to survive. They're going to have to sell themselves against a competitor that they haven't had before. There's a limit to how far judges can do that, obviously. But as I said in my address, I don't think we have to remain entirely silent about our impending doom.
Yeah, thanks, Lord Briggs. Fascinating talk. I'm interested in your views on how we can understand the impact of judicial use of AI without compromising judicial independence.
Well, I'm more troubled that it may compromise judicial training and the development and maintenance of judicial skills. It's true that the idea that AI is better than humans because it's free of bias is absolute nonsense. I recently described it as a canard, or in English, a duck. It obviously has built-in biases, and they're not visible necessarily to the user. For as long as it's only performing sort of checking the spelling, doing the boring bits, not doing the decisionary bits, that's fine. Problem is that once a busy junior judge succumbs to the temptation for it to go and do rather more than that, then of course that judge is exposing him or herself to bias, which affects his or her independence. Judges do have quite a lot of training to recognize and deal with bias, and even to get to grips with what is called unconscious bias. But it's a problem. It's not, I think, in the front of my current concerns.
Can I just
Tell me
Well,
about
just a couple of things. One, I think some of the more sort of straightforward uses of AI still have risks involved.
Yeah.
For example, summarization. I don't know if you've seen the Ada Lovelace report on the use of magic notes in the social work context. Anyway,
I'd like to have it if you'd like to send it.
I will send it. But so social workers using summarization tools, which are coming up with things like suicidal ideations that don't exist. These might find their way into the family court. So even if judges are just using summarization tools, this is distinctly different from using Westlaw to look up a case.
Yes.
They're performing a completely different function. And given that there's a sort of inability to, or a lack of research on judicial decision making because of concerns about intruding on judicial independence, I'm interested how we can analyse what impact even those basic use of AI has on judicial decision making within the constraints of the issue of not intruding on judicial independence.
You can probably see from the extracts from the Brazilian regime, which I read out, they've obviously had a deep debate about just how much disclosure judges have to make about their use of AI. And they seem to have settled for a compromise that he doesn't have to disclose it himself, but he can if he wants. But the court has to record it so that there's an audit trail if it needs to be followed. Now, I'm not suggesting that's where we will end up here. And on the whole, judges who have used AI have tended to say so and be very upfront about it. I don't personally think judicial independence is compromised by a regulatory requirement to disclose the extent of your use of AI. At least I wouldn't feel so, but I acknowledge that another judge might. I'm equally conscious that in its present form, open LLM AI is still just far too riddled with fakes, mistakes, and hallucinations to be capable of being actually relied upon at all. You've got to check everything it says. I went to an exhibition yesterday, a presentation actually in the Supreme Court yesterday by your Professor Jeremiah Adams Frassel, who's a professor here, who showed, he said they asked an AI platform to review a single judgment. It was the Unison judgment. And it came back and said, well, the highlights are these passages which it put in quotes, and every quote was wrong. It wasn't even an accurate quote. And it was just looking at one document. So at the moment, it's seriously unreliable. And my understanding is that although the judges in the general justice system, we're looking at it quite separately in the Supreme Court, are being cautioned against the use of any form of open AI, but they are having a sealed up, closed, leak proof, and I think much more hallucination resistant version made available to them.
But we won't know what the impact of that is unless they disclose that they're using it and have the ability.
Absolutely.
Yeah.
And those are all I'm not here to answer those questions. You can see it was a big problem. I think you can read between the lines, see it was a big issue in Brazil. I'm just saying, now's the time to get to grips with them. And they are problems that need to be ventilated in the public domain.
Okay, great. So we have this discussion in our BCS tutorials where we often say it's still not very good, it's still making mistakes. But as you pointed out in your speech, it's come on an enormous in the last few years. So there will come a point when it's going to quote Unison accurately.
Yes.
And
exactly.
There are, even when you think about those, as you put it, there's indispensable human qualities to judging. Even now, it will have a go, right? So you can actually ask these models, what is the legal rule? It can give usually a reasonable, accurate account. And then you can ask it, would that produce unfairness if it was applied in X, Y, or Z circumstances? And it will have a go at equity or mercy. And it will do it in, by processing huge amount of data that may not be available, that certainly isn't available to the single judge in a busy schedule. So What do you think is the irreplaceable human qualities that will survive even the improvement of the technology?
I was sitting on the train this morning coming down, thinking what the questions might be. And my first one, well, what are the irreplaceable human qualities? I think I don't think we should assume that it's got to take a human to see who's telling the truth. It seems to me that so much truth checking is done by judges now by looking at internal inconsistency if there are no documents, otherwise comparing oral evidence with documents. I don't think that's the area. At the moment, I think reasoning is an area. The losing party is entitled to reasons. I don't think the winning party can usually care less. But the losing party certainly wants reasons. There's a debate about just how far AI does or doesn't reason. It produces things that look like reasoning, but I think certainly your professor who addressed us yesterday in the Supreme Court said that it doesn't actually reason itself. It's just looking at what's happened in the past and mimicking other people's reasoning. So I think we're still there at reasoning, but that may only be temporary. Discretion, equity. Equity, the exercise of equitable discretion is all and utterly fact dependent on the actual case. You may look at precedent to understand what the general principle is, which are not applying rules, and current AI LLM models only give you what their training has taught them up to the point where they turned off the training, and that was before it was published, which may be as recently as 6 months ago, but it certainly isn't going to be about your case. So I think the exercise of discretion is an area where, at the moment, I can't see that when it's a true discretion, namely the application of a wide jurisdiction to come up with solutions to deal with problems in your particular case, I think it's currently being left behind. If an appeal court has to re-exercise a discretion, it does it on the basis of the facts that they are at the time the appeal court is giving judgment. So it is always done on an as now, right up to date basis. Developing the common law. AI is essentially something that looks backward to see what the precedent is. It doesn't look forward. It doesn't think, well, maybe we should tweak it a bit to cope with a change in socio-economic circumstances. I don't think. Open to correction, but I don't think it does. Dealing with problems for which there are no precedents. Again, it's essentially precedent. It looks back into the data to find an example where this has happened before. That's why it does medical diagnosis so well. And just making the loser feel they've been listened to. It takes a human rather than a robot, but that a lot of us think is one of the most important functions of a judge. Humanity, vocation, loyalty, accountability, humor, and transparency. If you give it to a robot, it's going to do it in the twinkling of an eye while it's doing 100 other ones at the same time. If you give it to a human, a judge has got to do it at a speed which can be audited, followed, understood, looked at. So that's an overview.
With the humour, do you also get the crankiness of the overtone?
If you do get grumpy and embarrassed AI robot.
Okay. Questions? Other questions, please? Rachel?
To what extent do you think we're going to get to a stage where the rules or the PDs impose the requirement to use AI? Or in my case, I was talking to you about disclosure and technology-assisted review. And as you rightly said, the investment in AI depends on the size of the law firm to a great extent. They have the resources for that. And recently, I've done a report for Business and Property Courts after a 4-year period. We started as a PD 51-2 for disclosure. It was 51U now. It's PD 57AD. But it's quite ironic that in that 4-year period, parties did not think that the costs had decreased. They didn't think the burdens of disclosure had decreased. They thought that the burdens on the courts had not decreased. And I think we have to keep in mind the overriding objective of the CPR, which is to decide cases in a proportionate way, given the value of the claim at issue. And I just wondered, to what extent do you think we're going to get to a stage where AI and TAR and whatnot will become imposed rather than a choice?
I certainly don't imagine that any rule is going to impose AI on a litigant. If it's imposed on the courts, it's because otherwise it will sink under the burden. So that's not a rule imposition, that's a practical management imposition. If we're not going to have a limitless amount of extra funding, and we're not. I certainly don't think it's going to be said that you've got to use AI. I see much more in terms of it imposing certain disclosure requirements if you're using AI, and possibly certain constraints on your using AI. I don't actually see the rules as necessarily the main place where the democratic control over AI is most likely to be exercised. I think it may well have to be done, as I said, with the stuff ground zero, and not from the comfortable confines of the CPR, because you could say, well, AI just enables you to do what the CPR requires more quickly and efficiently. And in a sense, that's true. But the real, it's more to do with, I think, it's to do with disclosure of the use of AI by litigants, but it's also going to be to do with the regulation of the use of AI by courts, or at least regulation which makes the extent of their use transparent, so there isn't a mismatch between what the public thinks they're getting and what they're really getting. I'm walking around in a cellar with no lights on, trying to feel my way, actually, and if nothing else, my speech is designed to be a cry for help, because we really need to get to grips with these problems before it's too late, and not be dragged along by the technical developments. We need to be in charge of them.
Well, the cry for help has been heard. Can you please, everyone, please join me in thanking Lord Briggs for a wonderful presentation. Thank you, everyone.